Everybody is ready, I think. Good morning to everyone. Hope you had a good Sunday with at least some rest. And we're ready to start the seventh day of this hearing. I see that Mr. Papadopoulos is already online. Is there anything we need to address before we turn to him?
Not for claimants, thank you.
No, Madam President.
What was that? Where does that come from? Is it?
Yeah, I don't know what's going on.
Is your microphone? Yeah. Maybe you can exchange microphones.
I think it's fine now.
Now it's good. Yeah, fine. Good. Mr. Papadopoulos, do you hear me?
Yes, I can hear you very clearly.
Excellent. We hear you
Thank you.
too.
Thank you.
Good morning, and
Good
thank
morning.
you for being with us. You're Thomas Papadopoulos?
Yes,
You're a lecturer at the University of Cyprus, is that right?
yes, I'm assistant professor of business law at the University of Cyprus.
Fine. You have provided two expert reports in this arbitration, the first one dated 18th of April 2019 and the second one 24th of January 2020. Is that right?
Yes, that's correct.
Do you have your expert reports with you there?
Yes, I have the documents here in opened in my PC. Yes.
Are these clean, unannotated copies?
Yes, there are clean copies.
Good. Are you alone in the room from which you testify?
Yes, I'm alone in the room. Nobody
And you
else is
have
here.
no access to information sources or communication channels other than the video platform that we use now?
Exactly. I don't have anything else apart from this platform.
Excellent. So as we go along, you may be shown documents. They will appear on your screen.
Okay.
And if you want to see more of the document, you wish us to scroll up or scroll down, you will just let us know.
Okay. Thank you.
Fine. You're heard as an expert. As an expert, you're under duty to make only statements in accordance with your sincere belief. Do you have you received a copy of the
Yes,
expert
I have it
declaration?
here. Yes.
Good. Can you read it aloud into the record, please?
Yes, sure. Expert declaration. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Fine. Thank you very much. So I'll turn to Respondents' Counsel for introductory questions first.
Thank you, Madam President. Good morning, Professor Papadopoulos.
Good morning.
I would like you to comment on the argument raised by Mr. Georgiades in his reports that the seat and registered office are used interchangeably in Cyprus company law. So to prove that, in his third report, in paragraph 3.6, Mr. Georgiades noted that there are certain cases in Cyprus company law when different terms are used to denote something with the same meaning. That is, that the Greek words onoma and eponymia are used interchangeably to denote the name of a company, and the words symbolos and dieffindis to denote a company director.
Yes. With regard to the Greek words διευθυντής and symbolos, Article 57 of Cyprus Companies Law, which transposes the second company law directive, puts these two terms one next to the other, which indicates clearly that they have a different meaning. The word διευθυντής means managing director, CEO of a company, while the word symbolos means, let's say, simple director, just a simple member of the board of the company. So the argument of Mr. Georgiadis in his report fails because Cyprus legislature uses these two words with a different meaning. With regard to the terms onoma and eponymia in Articles 4 and 351 Cyprus Companies Law, these two terms have exactly the same meaning. They mean labeling, distinguishing, characterizing a legal person. And the fact that the words onoma and eponymia have the same meaning is undisputed.
Thank you. So in his third report in paragraph 3.4, Mr. Georgiades argues that the company which moves its registered office from another country to Cyprus is not being reincorporated in Cyprus, which means that the place of incorporation and registered office may not coincide. Would you like to comment on that?
I disagree with this view. We have Article 354F of Cyprus Companies Law, which regulates the effects of registration of a company having transferred its registered office from a foreign country to Cyprus. Article 354F is a provision which states clearly that the company in question, from the date of the entry into force of the temporary certificate of continuation issued by the Register of Companies, is considered to be incorporated pursuant to this law. In other words, a company is incorporated in accordance with Cyprus Companies Law when it receives the temporary certificate of incorporation. This is a specific process called reincorporation, which comes together with the transfer of the registered office. The process of reincorporation is a process of cross-border conversion. This means that the foreign company is being converted into a Cyprus company with a continuation of its legal personality. This also means that here we have a change of applicable company law. The company stops being subjected to foreign company law and starts being subjected to Cyprus company law. Hence, companies following the process of Articles 354B to 354I, continuing in Cyprus, must have a registered office in Cyprus because they are considered to be domestic companies, and so Cyprus company law starts applying to them.
Thank you, Professor Papadopoulos. I have no further questions, Madam President.
Thank you. Mr. Anway, please.
Good morning, Professor Papadopoulos. My name is Stephen Anway. I am counsel to the claimants in this arbitration and will be asking you some questions about your expert report today.
Okay.
I would ask that you listen to my questions very carefully. Most of my questions are answerable with a yes or no answer. And particularly because you are testifying by video, I'd ask that you allow me to fully finish my question before you start your answer so we don't speak over each other. I'd like to first spend a little time understanding the corporate registration in Cyprus. If we could turn to CE 500, Article 3. And this is the Companies Act, and Article 3, you can turn to it. Let me just ask the question. The basic provision states that persons associated for any lawful purpose may, by subscribing their names to a memorandum of association and otherwise complying with the requirements of the law in respect of registration, can form an incorporated company with limited liability. correct?
Yes, this is Article 3.
And Section 15, and again, we can take you to it if necessary, but I don't think it's necessary, provides for company creation to be certified by the registrar on registration of the memorandum and articles of association, correct?
Yes, this is Article 15.
And you don't dispute that SEMB complied with these requirements, correct?
From the information that I have, it is not infringing these provisions.
You don't dispute the authenticity of the company register of SEMB, which is on the record as CE 53. I can take you to it if you like, but I don't think it's necessary. You don't
Can I
dispute the
have
authenticity?
Can I have a look at it, please?
Of course. CE 53, if we could pull it up, please.
Yes, please. Could you scroll and magnify a little bit, maximize, because it's not visible? Yes, I can see.
You took no issue with this document in your expert reports, did you, sir?
No, I didn't. Yes,
And you don't dispute, I'm sorry?
It looks, yeah, it looks lawful, yeah.
And you don't dispute SEMB's articles of association, which are on the record as CE 866. We can take you to that document as well if you'd like. But
Yes, yes, please. Can I have a look at it?
Let's pull up CE 866.
Yes.
And again, same question. Nowhere in your expert reports did you take any issue with this document, correct?
I didn't.
All right, let's turn back to the company's law in Section 102. I'm sorry, it's CE 120, Section 102. And again, the question's fairly simple. As I understand it, under Section 102 of the company's law, all companies incorporated in Cyprus must have a registered office in Cyprus. Is that correct?
Yes, from the time that the company is incorporated, must have a registered office in Cyprus. The registered office and the corporation go hand in hand. It's a prerequisite.
And you don't dispute that SEMB has a registered office in Cyprus, correct?
From the information that I have, I cannot comment on this. I cannot dispute this from the information I have.
And you don't dispute SEMB's certificate of registered office, which is on the record as CE 54. We can pull that up if you'd like to see it. But again, in your reports...
Can I have a look at it, please?
Absolutely.
Can you go a little bit up to have a look? Certificate, just a moment, a little bit down. Yes, situate at.
And I'll represent to you, sir, this is after SEMB moved its offices, yes. But again, you don't dispute the authenticity of this document either.
From the information that I have, I cannot dispute this.
And am I correct that a registered office can be maintained at any place in Cyprus, irrespective of the existence or type of the physical premises at that place, or the nature and extent of the company's rights to use the premises?
With regard to the requirements of the registered office, first of all, we're talking about the free areas of the Republic of Cyprus. With regard to the unlawfully occupied areas of North Cyprus by Turkey, then we have special provisions. Moreover, there are specific requirements in in law which state that, for example, outside the office of the registered office of a company, we must have a label with the name of the company, but pretty much there are no other specific conditions about the premises. I mean, what kind of building should be. There are also provisions that in the office, in the registered office of a company in Cyprus, certain registers must be kept, certain corporate information must be kept there.
And we'll come on to that in just a moment. You
Yes.
agree that the registered office of a company in Cyprus does not have to be the head office or the principal place of business of a company, correct?
Cyprus is an incorporation theory jurisdiction. So there is no requirement that the registered office and the seat must coincide within the same place. However, Cyprus is a mixed legal system where the notion of seat is recognized in parallel, of course, with the existence of the incorporation theory system that Cyprus adopts. So, in a mixed legal system like Cyprus, a continental law notion, such as seat, is used by Cyprus legislature in parallel with the registered office, which is the connecting factor in incorporation theory systems.
Professor, I'm a bit short on time given how much material we have. My question was actually quite simple. You agree that the registered office of a company does not have to be the head office or the place of business of a company? I think your answer was yes.
Yes, the registered office and seat are two different notions with different meanings.
Do you agree that Cypriot courts, in deciding their jurisdiction, have concluded that all that is necessary for jurisdiction is that the defendant have a registered office in Cyprus?
With regard to jurisdiction, we have the Brussels Convention. I can comment on Article 63 of the Brussels Regulation, where we have three specific connecting factors. We have the registered office, the statutory seat, as the Brussels Connection mentions this, but also we have the head office and the place of business as factors that provide jurisdiction.
Professor, I would again ask you to focus just on my question. We'll be going to that Brussels regulation later. My question was, all that is necessary for jurisdiction is that a defendant company have a registered office in Cyprus. Is that correct?
From the case law of the Supreme Court of Cyprus, there are cases that require the existence of a registered office there. Nevertheless, in the Serbia Cyprus BIT, the jurisdiction is provided with regard to the notion of seat, which is different.
Papadopoulos, I'm sorry to interrupt you, Professor Papadopoulos, but I think it would be good if you could just focus on the question.
Okay.
The question was not on the BIT. The question
Okay.
was just, is it sufficient for a Cyprus court to assess jurisdiction that there is a registered office in Cyprus? And I
Yes.
understand you to say yes,
Yes,
but
yes.
maybe it's better if you confirm it.
Yes, I confirm it that it is yes, it is a registered office. Yes.
Thank you.
Thank you, Madam President. And in fact, it's common that companies in Cyprus, whether belonging to local or foreign business persons, designate registered offices which are neither their head office nor their places of business. That's common. And again, just a yes or no answer.
Yes, yes, it's common.
And in Cyprus, it's common for companies to designate the address of a law firm or accounting firm or of another service provider as the company's registered office. It's common.
Yes, it's common, and there is also a specific statute for these companies offering administrative services, of how they are going to offer these administrative services to such companies. But yes, this is common.
And it's common in Cyprus for companies to maintain the necessary books and registers of the company at that address. Yes or no?
Yes, as far as this address of the law firm is the address of the registered office, yes, it is common.
And again, I can take you to all these different legal provisions, but I think all of these points will not be disputed. Number one, you would agree that one of the most important functions of the registered office is that documents may be served upon a company at the address of that office. That's from section 372 of the company's law, correct?
Yes, I agree that it is a place where the correspondence and the notices are served. This is the main function, registered office.
And a company with a registered office in Cyprus must keep at the registered office the registration of debenture holders. That's section 83, correct?
Yes.
And every instrument creating any charge requiring registration or any mortgage requiring recording. That's section 99. That must also be kept at the registered office, correct?
Yes.
And a register of the members of the company, that's section 105. That too must be kept at the registered office, correct?
Yes, the register of members also.
And a book containing the minutes of proceedings of any general meetings, that's from section 140, yes?
Yes. This corporate information must be kept there.
And the books of account, that's section 141, correct?
Can I have a look at 141, please? Is it possible?
Sure.
141.
Let's pull up CE 120.
Yes. In order to confirm. Yes.
So the books,
yes.
books of account must be
Books
kept
of account,
at the
yes.
Okay.
Yes, they can be kept also there.
And finally, the register of its directors and secretaries. That's section 192, correct?
As 192, can I have a look at it, please, to make sure again?
Sure, same document,
Of my confirmation.
192.
Yes, yes.
And Cyprus law imposes fines for non-compliance with some of these requirements, correct?
Yes. It's possible if a company violates some rules to be stricken off the register of companies if it violates such rules. Or fines, maybe.
Let's turn now to CE 54. And scroll down to the address listed there. You do not dispute, sir, that that is in fact a real address, correct?
From the information that I have, I don't know this place. I don't know where it is, but I cannot dispute it.
And you also don't dispute, it sounds like because you don't know, that this address is in fact at a commercial building? You don't dispute that?
I don't know this. I don't know this. So I cannot say, I cannot comment on this because I don't know.
And you don't dispute that SEMBI has had a physical office in Cyprus since it was incorporated in 2007, correct?
The Register of Companies does not perform any examination of the information submitted by the companies.
Professor, that wasn't my question. I'll ask it again. My question was, you don't dispute that SEMBI has had a physical office in Cyprus since its incorporation in 2007. You didn't ask about what the registrar
yes, I cannot
performs.
dispute. I cannot dispute this, but I would like to add that the Register of Companies does not check the information submitted to him, whether the physical premises exist or it is an imaginary place, or if there is a wrong address.
Professor,
but I cannot dispute it.
Unlike claimant's expert in this case, Dr. Georgiathis, you did not make a site visit to Sembi's registered office.
Excuse me, can
Correct.
you repeat? Because I wasn't-
Unlike claimant's Cyprus law expert in this arbitration, you did not make a site visit to Sembi's registered office. Correct?
No, I did not.
And so you offer no testimony to this tribunal about the actual office at all, whether it was accessible, who was there, what materials were kept. You don't offer any testimony about those matters.
No, I do not offer any testimony on these matters.
And so if we turn to Mr. Georgiathes's first expert report, paragraph 2.14, you don't dispute that Sembi's name is on the front of the building as shown on this picture.
If this picture is correct or true, I cannot dispute it because I see, but
And I will represent to you, sir, that Serbia in this arbitration has never raised a question about when this sign was put up, but I take it from your answers that you have no reason to doubt that the name has been up on the front of the building since well before this arbitration. You have no reason
Madam
to doubt
President,
that.
I have to object. Mr. Papadopoulos is not the witness of the fact, but the expert witness. So I'm not sure that these
Yeah.
are the questions
I-
proper for Mr. Papadopoulos.
No, this is on the border between fact and law, really, because it's a factual question, but it's obviously linked to the legal requirements. Mr. Papadopoulos, I understand that you have not gone to this address at Prodromou, I don't
Never.
remember the exact name. No.
never. I have
So-
never been there, never.
You have never been there. Do you know the company HLB?
No,
No.
I don't know this company.
Yeah, and you don't know Ames either?
The aims of this company, what is it
No,
doing?
the name that is on the
Ah,
sign.
the name? No, names, no.
No.
I have no idea.
So you have no way of knowing whether the Sembi name has been there or has not been there, or neither do you know for how long.
I don't know. I don't know this thing.
Thank you.
I have just one final question on this topic, sir. You don't dispute that Sembi's registered office complies with all aspects of Cyprus law. You don't take issue with
I
any legal
cannot-
aspect.
I cannot give a positive answer because I have not visited the registered office of this company.
Okay. Now, of course, you make the argument that the term seat under Cyprus law means something more than simply the registered office, and instead means the place of effective management and control. In fact, this is not the first time you've made such an argument to an investment treaty tribunal. Correct? You made the same
Yes.
argument to the Mera versus Serbia tribunal.
Yes, I did the same statement in the Mera versus Serbia arbitration.
Let me take you to that decision then. That's CLA 22. We can see from the front of the award who the tribunal members were. Dr. Segesser, Bernardo Cremades, and Yves Fortier. And if we turn to page 11, we'll see your name at the bottom as one of the testifying experts for Serbia. And I think you already agreed, but just to confirm, you made the same argument to this tribunal, to that tribunal that you're now making to this tribunal, correct?
Yes, I support the same view that seat and registered office have a different meaning in Cyprus companies law.
And in fact, the tribunal, although it doesn't identify you by name, summarizes your argument at paragraph 79. In fact, before that, but 79, I think, is probably the most succinct articulation of your position. You could just confirm that's the position that you offered to this.
Can I have a
tribunal.
look at it, please, a little bit? Can you maximize it a little bit because it's not visible? Just paragraph 79, okay? Yes, pretty much this paragraph summarizes my opinion.
And then on the next page, we see the heading, the tribunal's findings, just above paragraph 84. And in fact, the tribunal rejected the argument that you made to them on this issue, correct?
Yes,
And it rejected the position unanimously, correct?
yes,
And we can see, starting at paragraph 87, the arbitral tribunal finds it difficult to accept respondent's position that the term seat is ordinarily understood in international law to convey the place of effective management where decisions are effectively made. But the tribunal then goes on to talk about the issue under municipal law. If we could scroll to paragraph 90, the tribunal held, quote, the concept of a seat of a legal entity remains essentially a municipal law concept derived from civil law tradition and is foreign to Cypriot law, which is rooted in English common law. As confirmed by claimant's legal expert, former Attorney General of Cyprus, Cyprus law does not recognize any notion equivalent to the French concept or the German concept of real or effective seat. The Attorney General then goes on to propose that instead Cypriot law adopts the so-called incorporation approach to determining a company's law, and that as a result, a company seated in Cyprus is one that is incorporated in Cyprus and maintains a registered office in the Republic. And in paragraph 91 then says the tribunal considers that this approach of defining the term seat fitting in the present case. And I'll just read one more passage, and this is on the top of page, the next page, 24. In this sense, seat means the seat of a legal person, the registered office, the physical location of a company where it can be visited, where service can be made. The tribunal therefore accepts that the meaning of the term seat must be understood to have a reference to an actual location, place, or address. Thus, in the arbitral tribunal's view, the equivalent of this condition under Cypriot law is the registered office of an entity. Now, sir, the tribunal then goes down, if we could scroll down just a bit, and cites an earlier decision, another investment treaty tribunal that has also faced this same issue under the same treaty, and it's the tribunal in what we call the CEAC case. Are you familiar with that case as well?
yes,
And in that case, the tribunal took a different approach. It took a more expansive view of what seat meant under the treaty, correct?
yes.
And Professor
At the
Park
beginning.
dissented to that decision. I'm sure you're aware. In fact, he's referenced in this paragraph as well.
Yes, he had a different
And
view.
the additional requirements that other tribunal found are listed in paragraph 94. And I'd just like to go through them with you, and it's on these criteria that I'll be asking you questions. And I'll just,
Yes,
I'll read this language into
yes,
the record. So the tribunal in the Mera case says, paragraph 94, and I quote, the arbitral tribunal does not accept the requirements established by the majority in CEAC. The additional conditions applied by the majority in CEAC went beyond assessment of the confirmation of a registered office by relevant authorities to also include inquiry into, number one, the existence of physical premises, number two, a lease or license to use the premises, number three, accessibility of the premises for at least 2 hours per day, number four, the keeping of books and registers, and number five, the company's name affixed to the outside of the building. The present tribunal agrees with the position taken by Professor Park in CAEAC that this test finds no support in either domestic or international law, and that the adoption of that standard would require arbitrators to assume a policy-making mission in excess of their authority. But the tribunal goes on, and I'll come back to those factors in just one moment if we scroll to the next paragraph, to say in any event, even if the tribunal were to accept the test established by the majority in CEAC, these requirements are considered to be fulfilled in the present case. Now, if we scroll back up to the paragraph that I just read, 94, my question to you is, even if this tribunal applied the more expansive holding of the CEAC tribunal, the heightened standard for a seat under the treaty, do you dispute that SEMB satisfies every single one of these 5
Madam
requirements?
President, I must object. I was under the impression that we agreed that Dr. Papadopoulos is not going to give his opinion on issues of international law.
My question is more whether he takes issue, as a matter of his knowledge of the facts in this case, that all of these requirements are satisfied by SEMB, if he takes issue with any of them.
Are these requirements, where do these requirements come from? From Cyprus law?
These,
82 hours a day accessibility, and I think so, but you know it better.
these are the requirements that the CEAC tribunal found to apply.
But the CEAC tribunal has not invented these requirements.
Well, we can turn to the CEAC case in a moment. I think I've made the point.
I think it is correct that Professor Papadopoulos does not testify on international law issues. He's here as an expert of Cyprus law. So whatever your question is, it should be aiming at Cyprus law.
Okay. Why don't we then turn to paragraph 11 of your first expert report.
Yes.
You state in paragraph 11, in line with the above, there are 2 main theories on the recognition of a company as having valid legal personality, the real seat theory and the incorporation theory. And as I understand it, you acknowledge that some countries, particularly civil law countries, have a real seat concept, whereas other countries, particularly common law countries, have simply a incorporating theory concept, correct?
Yes.
And if we turn to paragraph 8, and I think you've already said this, but just to confirm, you state that Cyprus adopts the incorporation theory, and then you go on at the end of the paragraph to say that it's not absolute in form.
Cyprus, as a mixed legal system, does not adopt a pure incorporation theory jurisdiction. Adopts incorporation theory jurisdiction, but not in a pure form.
You would agree with me, Dr. Papadopoulos, that the Cyprus courts follow stare decisis?
The legal precedent, you mean?
Yes.
According to the Constitution of Cyprus and the Law for Administration of Justice of 1960, only cases before 1960 the Cypriot courts are bound by common law cases before 1960. After 1960, after the independence of Cyprus, they are not bound by these legal precedents, strictly speaking. So they can differentiate. Because after 1960, Cyprus moved from a pure common law jurisdiction, which was due to the fact that it was a colony, to a mixed legal system through the adoption of various continental law statutes, notions, approaches, etc.
You acknowledge that the Cyprus Companies Law was based on the English Companies Law of 1948?
The source of this law, the initial text, was quite similar with the 1948 English Companies Act. Since then, we had a significant differentiation through the years. Cyprus legislature did not follow all the amendments made by the English legislature. For example, the director's duties are not codified there and various other things. So pretty much Cyprus companies law followed, let's say, an autonomous way, an autonomous trend after the independence of 1960 with regard to company law.
But you don't dispute that the Cyprus Companies Law was based on the English Companies Law of 1948. That certainly is its legal.
The source, yes, the source of this legislation is English Companies Act 1948, like in all British colonies back then, almost all.
Okay, you were a country expert in a final report issued by the European Commission called the, quote, Study on the Law Applicable to Companies, correct?
Yes, yes.
And that study canvassed the European member states and how each member state determines if a company is a company of that member state, correct?
You're talking about this, can you repeat the question, please? Because it was not clear.
Well, the purpose of the study was to determine if a company is in fact a company of a particular member state.
No, the purpose was the private international law of companies, and more specifically, the law applicable to companies, this specific topic.
Well, let's take a look at the document then. It's RE 452. And it looks from pages 4 and 5 that this report was published in 2016. Does that sound right?
As far as I remember, yes, it was published.
It's a fairly recent document.
Yes.
And on page 8, we can see your name. Under Greece.
Yes.
And are you familiar with the experts for Cyprus? One of them is Christiana Markou.
She was one of my former colleagues at the European University of Cyprus, but I don't have any personal, or I don't know her any more than being a colleague of mine, a former colleague of mine, because now I'm at the University of Cyprus.
My understanding is she's now a professor. In fact, she teaches at the same law school as Professor Emilianithis, who we talked to on Saturday. Is that your understanding as well?
No, Christiana Markou is assistant professor or lecturer, I don't remember, at European University of Cyprus. Professor Emilianidis is rector and professor at University of Nicosia. These two are private universities. I am teaching at the State University of Cyprus.
Let's turn to two aspects of the report. First is on page 55. And while we're going there, let me just ask you, as I understand this report, it noted how some countries use a real seat test while others simply use an incorporation test. Do you recall that?
Yes, this is a generic categorization, but there are also some mixed situations. It is not, this is a generic categorization, but there are countries which are mixing these two theories, or they're applying other theories with different criteria. Depends.
Okay. So I have up on the screen page 55, and I'm going to start reading from the word however in the middle of the paragraph. However, a strict application of the real seat theory for incorporations and reincorporations in intra-EU scenarios would not be in compliance with the freedom of establishment. Still, there may be remnants of the real seat theory in some member states which might variously refer to the location of the administrative office or other fact-based criterions in order to mitigate certain effects of a pure incorporation theory. And then they go on and say, we can code the level of pureness of the incorporation theory as follows. A country gets a 1 if a connecting factor based on the incorporation theory is clearly formulated in legislation or through judge-made law, i.e. in a way that everyone, even non-experts, can grasp it, and no exceptions are provided. That is, no additional connecting factors based upon the location of a company's real seat. They then say a score 2/3 denotes either the situation that a connecting factor based on the incorporation theory is clearly formulated, but that criterion is subject to exceptions, or number 2, that legal experts can identify that the country follows a connecting factor based upon the incorporation theory and no exceptions are provided, but non-experts are uncertain about the position. And then a score of 1/3 refers to the previous scenario 2, but exceptions to the incorporation theory clearly exist. And finally, a 0 is about to the scenario where even legal experts cannot agree or cannot identify that the country follows a connecting factor based on the incorporation theory. In addition, in some member states, rules of substantive company law contain requirements for companies to establish or maintain a specific connection to the territory of the member state. And this was coded as follows: a country gets 1 if domestically incorporated companies do not have to have their headquarters or any other fact-based criteria on the domestic territory. A country gets 1/2 if domestic companies should have some factors on the domestic territory, but this rule is uncertain. It gets a 0 otherwise. So based on this description, 1, if someone receives a 1, it is the purest form of the state's incorporation theory. And if we scroll down to table 6, let's first take a look at what Greece received as a score. You see they received a 1/3 on the first analysis, the pureness of incorporation theory under private international law. And in the second category, they got a 0 on whether the substantive law is free from real seat elements. But if we look up at Cyprus, sir, we see that Cyprus received the purest form on both issues: the pureness of the incorporation theory under private international law and the highest score in terms of the substantive company law being free from real seat elements. Do you see that?
Yes, and I disagree with this position, and I can justify this if you would like to ask me.
Well, you recognize that this conclusion reached in this report is directly contrary to the testimony you're giving the tribunal. Yes?
First of all, it is, let's explain, it is not directly opposite, because I accept that Cyprus is an incorporation theory jurisdiction. It remains an incorporation theory jurisdiction, but it recognizes also the existence of the notion of seat. And this is because Cyprus is a mixed legal system where a common law notion like registered office and a civil law notion like seat can coexist harmoniously. And there are other areas of law which provide this harmonious coexistence of civil law and common law notions. For example, the old law of foundations and associations, which are legal persons, it was based on continental law, while the rest of the corporate legislation in Cyprus is based on Old English statutes.
Sir, my question was whether this finding was inconsistent with the testimony you're giving before the tribunal. Now, I understand you have your reasons for the positions that you've given to the tribunal, but I would respectfully submit that your position before the tribunal is that the word seat means some sort of real seat of effective management and control, when we see here on the second column, Cyprus is receiving a score that states its substantive company law is free from real seat elements. That's the language of the finding.
This is, first of all, this report was prepared on the basis of a questionnaire. Each national expert, academic or practitioner could give its own view. And then this is, of course, processed by the coordinators of the study. So this is the opinion, I guess, of Mrs. Markou. I disagree with this opinion. I think Mrs. Markou did not elaborate on this provision. For what I have seen, she has not taken into account comparative studies or a more, let's say, overarching view of Cyprus company law. So what I can say is that I disagree with this opinion, and I can justify this. I think to make a long story short, I think Mrs. Markou did not consider very carefully the mixed jurisdiction characteristics of Cyprus company law.
Let's turn to page 107 of this document to review the second aspect that I think is relevant. Page 107. And the paragraph that begins table 2. So table 2 below, which I'll take you to in a moment, summarizes first the effective residence requirements, if any, in all member states, understood as any requirement ranging from a mere business address to the principal place of business of the company. That's columns 2 and 3. And then down at the bottom, the last sentence, finally, we inquire whether commercial registers scrutinize in practice upon incorporation or on an ongoing basis that the company is in compliance with the substantive requirements of the state of incorporation. And if we look down to table 2, and again, let's go to Greece first, just to show the contrast.
Yes, Cyprus and Greece are two different jurisdictions, completely two different. Cyprus is influenced.
Sir, I'll ask you the question about this in a moment. If we scroll up to so we can see the heading on the table, there we go. We see in that second column, residence / real seat requirement for national companies. We see Greece says real seat relevant for most companies.
Could you maximize it because it is a little bit blurred? Is it possible to? Because this slide is blurred. Yeah, now it's clear. Yeah. Yeah.
So again, focused on that second column, it talks about residence or real seat requirement for national companies. We see that Greece is listed as having real seat requirements. And then the other columns go on to explain the details of the requirements and consequences if they're not met. And if we scroll up to Cyprus, and again, so we can see the heading, the same heading, residence, real seat requirements for national companies. And if we scroll down, we'll see it says no, period. Other than the registered office, there are no additional requirements of a physical connection between the company's operation and Cyprus. Dr. Papadopoulos, this report reflects none of the arguments that you're making in your expert reports to this tribunal, correct?
Correct, because I disagree with these findings. And first of all, I would like to clarify something here in this slide. It says that no additional requirements of a physical connection. Registered office is, according to Article 102, is the place where, the physical place where the correspondence is delivered. Of course, this must be clarified here. But I disagree with this statement because the text of the Cyprus Companies Law uses the term seat. The term seat was introduced for the first time in 2002 at the pre-accession period of Cyprus to the EU, and for a very long period of time, 16 years, in several amending laws, the Cypriot legislature inserted the term seat into Cyprus Companies Law. If this notion means nothing, or if it is the same, if it has the same meaning as registered office, then this would be against legal certainty. And of course, it would be a big disadvantage for Cyprus to make such confusion. If for a very long period of time, if the Cypriot legislature would have probably had identified and it would have corrected, but there is no mistake. The Cypriot legislature had the intention to use the term seat with a completely different meaning. How else can I explain the fact that for 16 years in several amending laws. A legislature is visiting again and again provisions and is inserting the term seat.
Professor, you note that this term seat was introduced for the first time in 2000.
Yes.
And in fact, why don't we turn, in fairness to you, to paragraph 18 of your first expert report. You state in 18, notably, Cyprus joined the EU in 2004, while the amendment introducing the term seat for the first time was adopted in 2000. I would suggest to you that the Cyprus courts and parliament used that word before 2000. And in fact, I'll just take you to two examples of it. Let's first turn to CE 121. This is a judicial decision from a Cyprus court where we can see it's dated 1994. And if we scroll down, the translated part shows that the court was referring to the registered office as the seat of the company back in 1994.
No, I think I disagree with this. If you want to ask me, I can have a look at the extract and explain you, because I have seen this case before. First of all, this is a case. The legislature started using it from 2000. And I can explain that in this case, the notion of seat and registered office have a different meaning.
You don't dispute,
can I explain
sir?
you? Just a moment, please. It says the applicants are a limited liability company incorporated. What does incorporate mean? We have Article 102, which states that the registered office is a prerequisite for incorporation. So here, seat means the effective management and financial control, because in the same extract, we have the term seat and incorporated. Incorporation means registration, registered office.
So let's turn to CE 501. This was a law passed in 1999, or an amendment passed in 1999, so it predates 2000. And I know you commented on this provision in your report, but
yes,
as we heard from claimant's legal expert on Saturday, this provision was enacted as a result of the Turkish invasion of Cyprus in 1974, when a number of companies became dormant when they were in the occupied territory. And so in 1999, as I understand it, the Parliament passed this amendment, which effectively lifted the obligation on those companies to be making certain filings of financial statements and the like. And you can see that this provision specifically refers to seat or place of business. This had nothing to do with EU accession, did it, sir?
First of all, Cyprus started its preparation for access to the EU since 1999. This was their first contact. Secondly, I would like to add that it says the basic law is amended by adding at the end of the following special provision. So this is a provision that is annexed at the end. It is not an article of Cyprus Companies Law amended. And with regard to this provision, it concerns companies with links to the north part of Cyprus, which is unlawfully occupied by Turkey since 1974. And it tries to protect these companies and remove some burdens that corporate legislation imposes on them. So it uses, okay.
Let's turn to CE 850.
Can I, is it a new question, a new exhibit? Because I would like to add something to the previous one about the use of seat, these three connecting factors. Is it possible to go back a little bit and explain it?
If we could please turn to Article 63 of this document.
I think
Can we go back? Can we go? Yes.
To go back to the prior document?
Yes, please.
I understood he wanted to go back to the
Yes,
prior
please.
Okay.
exhibit.
Yes, please.
Can I just ask a clarification about this prior exhibit, which was C501? It says seat or place of business. Do you understand these to be synonymous?
No, it is different because the city is a place of, it's a larger notion, it's a place of effective management and financial control. The place of business is the place of the activities, it's a shorter notion, and the whole of their property. So the Cypriot legislature used these three connecting factors in order to expand the protection of this provision and catches as more as possible of these companies which are, let's say, trapped at the occupied part of the north of Cyprus. It says here that companies that were registered, so companies that were registered as are companies with registered office at the north of Cyprus. This is the address where correspondence goes, and this is the address of their. This is the address of the registered office. And in addition to that, we also have seat, place of business, or property in the north. Yes,
I think
that's
it's
what I
clear.
wanted to explain.
Thank you.
Okay. If we could turn now to CE 850, I'll represent to you, sir, this is the Brussels Regulation on Jurisdiction and the Recognition and Enforcement of Judgments in Civil and Commercial Matters.
Yes.
Now, this is from 2012, so this is well after Cyprus joined the EU, correct?
Yes.
And if we turn to Article 63, it says, quote, "For the purpose of this regulation, a company or other legal person or association of natural or legal persons is domiciled at the place where it has statutory seat, central administration, or principal place of business." And then it goes on in Article 2 to say, "For purposes of Ireland, Cyprus, and the United Kingdom, statutory seat means the registered office." Could we go back to that provision, please? Or where there is no such office anywhere, the place of incorporation, or where there is no such place anywhere, the place under the law of which the formation took place. So here we see in subsection 2 the three common law jurisdictions in the EU, and this regulation was clear that what determines whether a company is domiciled is not the principal place of business for these three countries, but rather the statutory seat, which it says means registered office. Correct?
No. Statutory seat is a term different from the notion of seat. Statutory seat and seat are different. And I can procure some proof of this from the area of company law, because this is an instrument of a civil procedure. We have the European Company Statute, the regulation of the European company, the Societas Europea, which uses again in the English text the term statutory seat. When the Cypriot legislature in the national regulations facilitating the implementation of the European company law regulation used the term registered office as corresponding to the term statutory seat. So you give me a civil procedure instrument, I'm explaining to you in the context of a company law instrument that the term statutory seat in European regulation were implemented in Cyprus as a registered office. And the term seat is the head office. And we can
sir,
see, yes.
You see in section 2, when it specifically refers to the three common law jurisdictions, that it does not use the option listed in 1C, principal place of business.
Cyprus is a mixed.
Whether or not you distinguish between statutory seat and real seat, the fact of the matter remains that subsection 2 does not refer to the principal place of business when referring to the 3 common law jurisdictions within the European Union?
This is a civil procedure instrument. I'm explaining to you in the context of another EU law instrument from the area of company law, such as the European Company Statute, that the Cypriot legislature transposed the same term, statutory seat, from a European company law instrument as a registered office. I have referred in my report also to European company law regulations and also to the implementation in Cyprus of directive regarding the participation of employees in the board of European companies. And even in this text, in the national law implementing the directive accompanying the European Company Statute for the participation of employees, Cypriot legislature again transposes the term statutory seat as a registered office, and head office means seat.
Dr.
If we
Papadopoulos,
look, and last sentence, if we look at various other instruments, tax law, insolvency law, insurance law, banking law, we're going to see different notions: statutory seat, head office, actual center of administration, place of business operation, used with different notions. We're focusing on company law.
Dr. Papadopoulos, there are 6 provisions in the Cyprus Companies Act that use the word seat, and you cite them. And Dr. Georgiathis has testified, and I know you're familiar with his position, that those provisions say nothing about effective management or control and make perfect sense if one just interchanges the word seat for registered office. And while I don't have time to go through all 6, let me just go through one. Let me pull it up as CE 499. And I direct your attention to section 354K. Now, what's striking about this particular provision, which is one of the instances you rely on where the word seat appears, is that the title of the provision says transfer of registered office of companies to and from the Republic. And then the provisions to which that relates down below, you see in C, talks about the date on which it is proposed to establish the seat of the company in the particular approved country or jurisdiction. I mean, plainly, when you have the title using registered office and then the provision which specifically talks about the date on which the transfer will occur, it refers to seat, the legislature is using those terms interchangeably.
No, he does not use interchangeably. First of all, the Cypriot legislature would have never used a term at the title with the same meaning, with a different term in the main text, because this would be absurd and against legal certainty. This proof, please let me to finish. A registered office is used with a different meaning at the heading, and at the main text, seat has a different meaning clearly. That's why the Cypriot legislature uses this. And I have in mind that in his report, Mr. Georgiadis said that this is poor drafting. But it's not poor drafting, because this provision is very important for Cyprus because it attracts reincorporations. So the Cypriot legislature paid much attention to this provision and drafted very carefully, because how a foreign company is going to be reincorporated in Cyprus if there are such kind of vague points. It's clear. Registered office at the top, at the heading, has a different meaning. Seat at this provision 354K has a different meaning.
Well, let me test what you just said, which is the legislature would never use different words to mean the same thing. And let's turn, it's the same document, it's just above it, in fact, to section 3472A i. And you see in the last subsection, i, in the case of a legal person, its name and registered or principal office. Here, the legislature used the term principal office to refer to the main office. And so if your theory were correct, including that the legislature always uses consistent words, they would have used the term seat here, but they didn't.
First of all, principal office might have a different meaning here. We can discuss this, of course. Registered office and principal office are again two different notions. And of course, when the Cypriot legislature uses two different terms, according to a textual interpretation, it means different things. A textual interpretation is the safest method because in Cyprus, we do not have travaux préparatoires. We don't have explanatory memoranda. It's Cyprus is a small jurisdiction, and unfortunately, there are no resources to support this thing. So they have different meaning.
Now, both you and Mr. Georgiathis cite to the English translation of the Greek language original of the Companies Act, and I understand that in some instances the word seat is translated into head office, but there are other times where it's transferred as registered office. But my only question to you is, you acknowledge, do you not, that in general official translations in foreign languages do not substitute the statutory text drafted and published in the official language of the state? You agree with that?
I agree that the original text is the text in the national language, the Greek language, but in the context of an international arbitration, any kind of materials like an official translation provided by an official public law body can help us. Because as I have cited in my report, the Office of the Law Commissioner of the Republic of Cyprus is responsible for providing official translations and consolidations of law to the ministries and other authorities of the Republic of Cyprus.
I'd like to turn to my last topic now, which is what claimant's legal expert has described a lack of support for your position. And if we could turn to paragraph 14 of your second report, please.
Can you magnify, can you maximize it?
You say, hence, there are
Yes.
no references to authorities in my report because there are no authorities in the bibliography of Cyprus company law with regard to the interpretation of notions of seat and registered office.
Yes.
So I just want to be clear. You acknowledge that you have no authorities saying that Cyprus law distinguishes between seat and registered office, correct?
With regard to this specific issue that I'm examining in my report, with regard to specific topic, there are no papers, as far as I know, which scrutinize this issue and provide an answer.
And you admit that you have no authorities saying that Cyprus law distinguishes between procedural and substantive company law, correct?
It is an inherent, yes, I agree that there are no authorities supporting this. An inherent problem of Cyprus law is the lack of authorities. This is because the first law school was set up in Cyprus only in 2006. Until this time, Cypriot lawyers were educated abroad in Greece or in England or elsewhere. So there was no academic community. There were no university law schools which could provide articles, papers, monographs, topics discussing these issues. There were only publications written by professionals, by practitioners, which were quite superficial in their approach. You can imagine that this is an inherent problem, the lack of authorities, and we are called to interpret these provisions in the light of the lack of these doctrinal works.
And you have no authorities saying that Cyprus law defines seat as the place of effective management and control, correct?
I used, of course, some, because there are no specific doctrinal works provide answer to this specific issue with regard specifically to Cyprus law. So I referred to international bibliography in order to find a definition and support this. In the light of the fact that Cyprus is a mixed legal system, I try to use an EU and comparative law bibliography, which would help me to provide a definition for the notion of seat.
And you have no authority saying that Cyprus law applies the real seat test either, do you, sir?
No, I don't have any authorities. I'm in the absence of bibliography and travaux préparatoires. I'm using a textual interpretation and see that Cyprus legislature is using the seat, and I try to interpret it accordingly on the basis of the thorough analysis that I did on my expert report.
Madam President, I have no further questions.
Thank you. Any questions and redirect Professor John?
Only one, Madam President.
Yes, please.
So, Dr. Papadopoulos, you were asked earlier by claimant's counsel whether it is common in Cyprus that companies designate addresses of accounting firms as their registered office. Do you remember?
Yes, I remember.
So is it also common in Cyprus that sometimes these accounting firms are administrating hundreds or even sometimes thousands of companies?
Exactly. Most of these companies are administering and offering administrative services to dozens, hundreds, sometimes thousands of services, thousands of companies. They are professionals and they are doing this job, offering registered office and services to these dozens of companies.
So those accounting firms, they're not putting up on their office buildings labels of all of companies that they administer.
Yes, this is impossible. For example, a large auditing firm administering thousands of companies, it is impossible to put labels outside for every company. And this is unlawful, of course.
Yes, so do you maybe know how they decide which company's label to put at the office building? And if you don't know this, it's perfectly fine.
I don't know. I don't know. This maybe if it is a best customer, if it has paid an additional fee, I guess, if it puts some pressure on them, but I don't know actually. I must say I don't give the right answer.
Thank you. No further questions, Madam President.
Thank you. Do my colleagues have questions? Professor Papadopoulos, I ask myself whether the word seat in and of itself is not somehow misleading, because when you use seat, one doesn't know whether you mean the statutory or the, which you could also call the corporate seat, and or the real seat in the sense of the effective place of business activities. What would you say to this?
Taking into account that Cyprus companies law uses the term registered office, and in parallel uses also the notion of seat, I conclude from my analysis that seat is a place of effective management and financial control. Otherwise,
yes, can I ask you why you conclude this? Because one could also think that registered office is simply a terminology from common law, and seat is a terminology from civil law, and therefore they're not different. What would you say to this?
I would say that this is, I mean, I had a look at the international bibliography due to lack of Cypriot bibliography and Cypriot cases defining this term. And I found out that the most appropriate definition, which is adjusted to the needs of Cyprus as a mixed legal system, is the definition that I provided. I had a look at the national bibliography. I had a look at the monograph of Bir Meyer, a professor from Maastricht University, who is an authority in the area of corporate mobility and runs various EU projects on this area. And I found out that the definition provided there is the most appropriate for Cyprus as a mixed legal system and as a country in which in its company law statute, we have a simultaneous use of these two terms.
Now you lost me. What is the most appropriate definition that you refer to?
Is the definition of effective management and financial control. It is I concluded that SID means effective management and financial control because it is adjusted more to the text of Cyprus companies law.
And this you established on what basis? Can you say this again?
Because first of all, the text itself uses these two different terms. And secondly, Cyprus is a mixed legal system introducing constantly civil law notions, such as the notion of SID.
Good, thank you. I had another question that arose when you gave your answers about section 354K, that is the section of the Cyprus Companies Law about transfer of registered office, and then the title says transfer of registered office, but the provision itself uses the word seat. And you're saying when it uses the word seat, that means place of effective management. But that would then mean that you cannot transfer the a corporation from a foreign corporation into Cyprus unless you transfer the effective management. It would not be enough to transfer the registered office. Is that right?
No, this is a provision which it is Cyprus remains an incorporation theory jurisdiction, and it is possible a foreign company to transfer its registered office only in Cyprus and keep the seat outside Cyprus. This provision talks about information that should be provided to the
So you
authorities.
can transfer your company into Cyprus, making it therefore a Cyprus company, and keep what you call the seat and what we, to avoid misunderstanding, would now call effective management abroad.
Exactly, yes.
Okay.
It is possible to do this because Cyprus remains an incorporation theory jurisdiction. And of course, it is possible for to do this, and it happens quite common in practice.
Thank you. I have no further questions, no clarification. So that ends your examination. Professor Papadopoulos, thank you very much for your assistance this morning. And now you can leave the Zoom meeting if you so wish.
Just a small sentence. I have also written an article on the incorporation in Cyprus law, published in the National Journal of Law and Management. So I'm explaining this position more extensively there. Thank you so much.
Thank you. Goodbye.
Bye.
So is this a good time to have a 15-minute break, and then we go over to Mr. Gretchek? And we're sorry, this was a mistake that they were labeled as legal experts. Obviously, they're not legal experts. And so I understand they will make presentations, right? Good. Mr. Gretchek, good morning. Can you switch on your microphone? Press on the red part.
Yes.
Yes, now it's fine. You're Christoph Gretchek.
Yes.
You're a property consultant established in Warsaw, and you have your own practice called Polish Properties.
That's correct.
Yes. You have provided one expert report dated the 3rd of October 2019.
Yes.
You're heard as an expert witness. As an expert witness, you're under the duty to make statements only in accordance with your sincere belief. Can I ask you to read the expert declaration, please?
Yes. I solemnly declare upon my honour and conscience that my statement will be in accordance with my sincere belief.
Thank you. To whom do I give the floor for direct questions? No,
Yeah, the
actually, it's
presentation,
not
yeah.
direct questions. I should give you the floor, sir, for your presentation. And you remember that you have 30 minutes at the maximum.
15 minutes.
15?
This is an internal constraint.
Good.
I've been told
Now
15
you
minutes.
know what they did to you, yes. Good. Please go ahead.
Okay. Madam President, members of the tribunal, I'll do my best to present the salient points of my expert report in the next 15 minutes. And if we can have the next slide. By way of introduction, my name is Krzysztof Grzesik. I'm a chartered surveyor, recognized European valuer, and I've been practicing valuation in Poland for the last 30 years. That said, I've also been engaged in valuation work throughout Europe, United Kingdom, Poland, countries in Central and Eastern Europe, and I've been involved with the Serbian valuation profession since 2013, when I was invited to co-author Serbian national valuation standards, and I also advised the Serbian Ministry of Finance in connection with the development of valuer licensing in Serbia, which was finally implemented in 2017. Next slide. So the purpose of this presentation is to focus on the disputed issues concerning the assessment of the market value of BD Agro construction land in zones A, B, and C. This is the area which is worth some 85% of the total value, hence my focus on this land. And I'll start with reading what I consider the most important sentence within the valuation profession, and that is the definition of market value. And market value is the estimated amount for which the asset should exchange on the valuation date between a willing buyer and a willing seller in an arm's length transaction after proper marketing, wherein the parties had each acted knowledgeably, prudently, and without being under compulsion. So that is a definition of market value, and in the interpretation sections of both international and European valuation standards, it's set out that market value is measured as the most probable price reasonably obtainable in the market. It is the best price reasonably obtainable by the seller and the most advantageous price reasonably obtainable by the buyer. I emphasize the best price reasonably obtainable, the most advantageous price reasonably obtainable. What those words mean is that this is not only about an arithmetic or mathematical conclusion. To arrive at the best price reasonably obtainable requires also valuer judgment, experienced valuer judgment. And of course, mathematics and arithmetic plays an important part, but only as a tool. So this is not about statistics, this is not about medians or averages. And whilst on the subject of valuation standards, throughout the various reports that you have before you, there have been a lot of contentions about one valuation being in line with international valuation standards, another valuation not being compliant. What I would say is this: there are three recognized international valuation standards in Europe. They are the international valuation standards, the European valuation standards, and the standards published by the Royal Institution of Chartered Surveyors. Each one of those standards has a different emphasis. So whilst we can say in general that we are working in line with internationally recognized valuation standards, it's impossible that we can be consistent with each one of those standards at the same time. We have to remember that there are different sections within these standards. What they have in common is a section where there is an outline of the different valuation concepts, definitions such as market value, fair value, investment value, and those definitions have been around now for at least 30 years, so they're common to all standards. What these standards also have are sections which indicate how a valuer should behave when undertaking a valuation. For example, he should avoid conflicts of interest. He should ensure that before he undertakes a valuation, he has the instructions in writing. The valuation standards also include a section on methodology. Now, when this is methodology describes the typical methods used by the valuation profession worldwide. And the standards are on methodology, they're descriptive and not prescriptive. In other words, it's not a cookbook, it's not a rule book telling valuers how he must undertake a valuation. So it's very important to distinguish, when we talk about international valuation standards, it's very important to distinguish that they do have different sections, and those sections are more prescriptive, less prescriptive. But generally, internationally recognized valuation standards are guidance, high principled guidance to valuers. They are not legislation. So we go for the next slide. This is a table which summarizes the main valuation issues in dispute between my valuation, which is on the left-hand side of which is left-hand column, and the valuation of the respondent's expert witness, Daniela Ilic. And you'll see on the separate rows that the areas of dispute. One area of dispute, I'm pleased to say, has been solved. We've agreed that zones A, B, and C have an area of 2,794,554 square meters. And then when we come to valuation approach, both myself and Daniela Ilic apply what we call the comparative approach, which is based on valuing the subject property by reference to sale prices of other comparable properties in the area at around the time of valuation. Now, in this particular case, the actual sale prices, which is really the basis of comparative approach, actual sale prices have been very scarce. And so both Daniela Ilic and I had to rely on other secondary evidence, if you like. So I've relied on the evidence of valuations in expropriation cases, and I'll come to deal with that in the later slide, whereas Daniela Ilic has relied on asking prices listed by various estate agencies on the internet. So that's the difference between us there. And as a result, I have valued the zones A, B, and C at 30 euro per square meter, and Daniela Ilic has valued them at 21 euro per square meter. And then she's deducted 30%, which I understand is for the large size of a site, to arrive at a a rate of 14.7 per square metre. Another area of dispute is in respect of what we call the conversion fee. Because certain parts of this, well, the whole of this site is agricultural, which has been turned into industrial or business use, some of the parts of that site are under Serbian law subject to what's known as a conversion fee, which is based on 50% of the value of the agricultural land. So I have calculated the conversion fee at an area, using an area of a revised area of 1.634 million square meters at an agricultural value of 1.85, and I've taken 50% of that to arrive at a conversion fee of 1.5 million. On the other hand, Daniela Ilic has a slightly larger area. She's applied an agricultural value of 3.4 euro per square meters at 50%, so her conversion fee is just over 2.9 million euro. I should point out that although Daniela Ilic applies an agricultural value of 3.4, in her main valuation she's adopted an agricultural value of euro 1 per square metre. So and I can't understand why the difference, but there is that difference. So when we look at the total market value from all of that, I arrive at a revised market value of 82,325,000 euro, and Daniela Ilic has arrived at a valuation for zones A, B, and C of 39 million, just over 39 million euro. So go next slide. Now, I mentioned that my comparative approach evaluation has been based on the evidence of land valuations in an area called Batajnica for expropriation purposes. Now, this is, if you look at the aerial view on the right-hand side of this slide, you'll see Batajnica there up to the north, and you'll note that this is an area which is quite close both to zones A, B, and C of the BD Agro, and also they're more or less equidistant to Belgrade. The nature of these properties are originally agricultural. For development, they would require extensive investment in infrastructural works. So from a development point of view, in my opinion, both sites would carry similar values. Now, the authorities have been, over the years, the authorities have been acquiring various sites in Batajnica for the purposes of developing what's called an intermodal transportation hub and logistics center. And you'll see on the right-hand side aerial view, those areas which I have edged in red indicate that the sites which have been expropriated for the purposes of developing this intermodal centre, and you'll see the prices at which they've been expropriated. So they range between 28 euro per square metre to 37 euro per square metre. Now, one of the criticisms of my reliance on this on this evidence is that it's based on valuations post the valuation date. It's based on valuations from 2016. However, I would contend that this evidence is permissible because at the time when the actual valuations were being carried out, the tax assessors, the assessors who would have undertaken a valuation, would have had regard to evidence at around the time of valuation. They would have undoubtedly had regard to evidence from 2014 to 2015. So on that basis, I contend that this evidence is admissible. However, there is a fallback here because there were also acquisitions in 2013. And The 2013 acquisitions are shown coloured blue. So you'll see all the arrows pointing to the blue areas. They were all acquired in 2013, or the valuations were in 2013, at 27 euro per square metre. Now, I would also add that this is more than just third-party valuation. These are valuations which resulted in transactions. They resulted in the landowners being expropriated and at these valuations. And of course, if the landowners were not satisfied with the valuations on offer, they were entitled to appeal and try and either negotiate or seek higher valuations in court. So that is my evidence supporting Euro 30 per square metre on the basis of transactions ranging from 27 to 37 euro per square metre. And then if we go to the next slide, this is the approach of Daniela Ilic, who relies on asking prices. And this is the list of her properties which are which were put on the market. And as far as I'm aware, she found this information from the internet, from estate agencies' web pages, and the rates vary from 1247, which is item number 2, to item number 4 with 23.95. Now I have some problem with this set of comparables because from our fact-checking exercise, for example, item number 1, we've not been able to determine the exact location of the property referred to. Number 2 is agricultural land with no regulation plan in place, so that is an agricultural value. Number 3, again, we've not been able to determine the exact location of the property. And number 4, equally, we've not been able to determine the exact location of a property. Number 5, we know it's in an industrial zone. So the problem I would have with these set of asking prices is that because the actual properties were undetermined, the locations were undetermined, it would be very difficult to carry out the necessary thorough analysis required in order to accept asking prices as evidence in a comparative approach valuation. That said, if we go to the next slide, you'll see this is in Daniela Ilic's report. She did actually identify 2 actual transaction prices, the highest type of evidence which a valuer could hope for. And these, item number 1 here was a sale of 2 land plots at 33.95 euro per square metre, and search in Dobanovci 28.4. And what is relevant, particularly relevant here, is that item number 2 is a site which is actually adjacent to the BD Agro land. And therefore, I can't understand why this comparable transaction was rejected. I would have thought it's highly relevant. It's right next to the BD Agro farm. So that is the evidence of Daniela Ilic. And then there's one more item of dispute. As I mentioned earlier, Daniela Ilic arrived at a value of 21 euro per square metre, and then she deducted 30%, which I understand from that sentence, which I don't fully understand, but the gist of it is that she has deducted 30% for the size of the site as a reflection, she says, of her experience in valuation of land. Now, if that is the case, I have to say I take the complete opposite view. And from my experience, the subject property it's an attractive opportunity for any international developer to acquire a large, readily assembled site for development, and that developer, in doing so, would save the need for several years of problematic land assembly. Now, such a large area of land would undoubtedly, in my view, attract top-end developers. They would be seeking economies of scale. They would have financial muscle. They would prove attractive to the financing banks, who are only too ready on the lookout for large chunks of property to lend upon. Indeed, there is a justification for saying, with such a readily available large site, there may be justification for a premium. I've taken the conservative approach. I've not speculated about the size of such a premium, but what I'm absolutely sure about is that there is no justification for a 30% deduction. And if I can go back to illustrate this point, if I can go back to the slide number 5, which was the aerial views, you'll see this demonstrates the point. Here we have Zone A, Zone B, and C, one large tract of land available for development. Of course, it's not available for development just yet because there needs to be a lot of infrastructure works, but a lot of investment still needs to go in there to make those sites available for development, but that is reflected in the price. On the other hand, if we look at the Batainica land, here we have a desired future development of a logistics center, but the authorities have had to assemble that land plot by plot by plot, year after year after year. So it's taken several years for the authorities to assemble the land needed for that intermodal transportation hub. You'll see that in 2013 they were undertaking valuations, and it's only today, almost 10 years later, that they're now able, having assembled much of this land, they're only now able to start the development. So it's a huge disadvantage, I believe, to look at individual small plots of land and then and not fail to recognize that if this land in Batainica had been one huge tract of land, it would be more valuable. That is my contention. I believe that was my last slide. Yes, no. The last slide is a table of comparison of all evaluations. I mentioned to you that I focused largely on the valuation of the construction land in A, B, and C at the 82,325,000. But there is also other construction land which I have valued at just over 3.5 million against Daniela Ilic's valuation of 1.3 million. There is also agricultural land which I have valued at 10 million and Daniela Ilic at 6.3 million. So you can see a vast difference between us. So I am nearly at 96 million euro as against Daniela's nearly 47 million euro. So that completes my opening presentation, Madam President.
Thank you. Can I give you the floor now, Mr. Gretchek?
Thank you, Madam President. Good morning, Mr.
Good morning.
Gretchek. My name is Vladimir Đerić, and I am counsel for respondent. And I'm going to ask you a few questions about your report and about your presentation. Mm-hmm. Now, let me start with the following. You wrote your report at the time there was a second round of submissions in this arbitration, and then there was a third round, and we didn't see a new report from you. So, are you familiar with what happened in this case after your report?
So after my report, I understand there were further reports. I didn't have any more involvement after my report, but I do understand there were further reports, and I do know that Daniela Ilic did have second report, and I have had the benefit of seeing that report. But it was a report which I understand was more directed at commenting on Dr. Richard Hearn's valuation.
Right. And have you seen the following report from Dr. Hearn? His
I
third report.
haven't read it, no.
Okay. Have you seen Dr. Hearn's second report, which was filed in parallel with your report?
I would have seen that, yes, I did.
Okay. Now, if we take a look at paragraph 1 of your report, it sets out your instructions, right?
That's correct.
And, sorry? Oh, we don't have the screen, sorry. Just wait for a second so everyone can see the... If a technician could help us, please, that would be great, thank you. Okay, so we are back, and we look at your instructions, and as I see it here, and you will confirm that you had instruction to revive and opine on Mr. Hearn's report, first report, and on Mr. Coven's report. And you also were supposed to give an opinion on the market values, right?
The development of my report ended up me giving an opinion on the market values, yes.
Okay. So, and today you did the same thing. So, is this an opinion? Do you really opine here, or you provide your valuation?
An evaluation is an opinion.
Yeah, but is this a proper valuation that you have provided us with? Okay. Okay, if we can go now to the paragraph 3.1 of your report, and it sets out the evidence that you have seen, right?
Yes.
And would you agree that most of the documents that you mentioned here are valuation reports of other people?
Yes.
Okay. And then there are two regulation plans. One is for Batenica, another for Surčin. This is a little bit down. Yes, that. You can see 3.1.21 and 3.1.22. You have it on the screen as well,
Yes.
if you wish to look at the screen. Does this mean that you did not by yourself search for and look into comparable transactions, asking prices, other usual information that is used in valuations?
Yeah, I was very fortunate in that I started this case by being instructed to opine other valuations, including Dr. Richard Hearn's, and I found that the research that was put into, that Dr. Hearn carried out, was quite detailed. So therefore, when subsequently moving on to expressing my own opinion of the market value, I was able to rely on much of the evidence which had already been researched by Dr. Richard Hearn.
Right.
And those helping him in the information gathering stage of the valuation. Having said that, I did visit the subject property, particularly zones A, B, and C. I did an inspection, and also I toured the surrounding area.
Okay.
So I familiarized myself with the evidence that was already there.
Okay. So I take it that you did not only, I mean, from what you have said, you did not only read and refer to Dr. Hearn's report, you also looked into the evidence on which the report is based and to which the report refers. Is that correct?
I had regard to it, yes.
Okay. But you did not collect that evidence by yourself?
No, I did not collect that evidence by myself.
Actually, I now see that you mentioned some of the evidence that Dr. Hearn also mentions in this list of the evidence that you rely upon, but you don't mention everything. So this is a selection, I would say, or not?
Well, what we have to remember is when Dr. Hearn provided a valuation which is a range, I then moved from there to provide a valuation of one expression of an opinion of value at the valuation date, which is the market value. So that being the case, I largely relied on the evidence that helped me arrive at the market value at the date of valuation. Not all the evidence which was provided in the Dr. Hearn report, I believe was relevant to my opinion of the value as at the date of valuation.
Right.
For example, there was some evidence of transactions which happened many years ago, which I felt wasn't relevant to the date in October 2015.
So you're saying that in this part dealing with the evidence that you discussed, and which is called nature and sources of information, you sort of put in the evidence that is directly relevant for your report, whilst the other evidence you did not put in but consulted. Right?
Well, I expressed my opinion of Dr. Hearn's report in general, but then moved on to express my own opinion of the market value at the date of valuation. And in expressing that opinion, I had regard to the evidence which I thought was relevant.
Yeah, but did you put that evidence that you thought was relevant for your opinion in section 3?
Well, in section 3, I think section 3 contains all the material, including expert report of Dr. Richard Hearn. So most of the evidence that I relied on was actually in the expert report of Dr. Richard Hearn. Okay. So it's there.
Okay, so when you refer there to Dr. Richard Hearn, you refer also to all the evidence that Dr. Richard Hearn is using?
I refer to his whole report, but when I come to expressing my own opinion, I do set out in my report that evidence upon which I've relied upon in order to arrive at the market value.
Thank you. Now, you have mentioned that today, but let me just go back to that for a sec. At paragraph 511 of your report, you state that Dr. Hearn's report was in line with internationally recognized valuation standards, the only exception being, quote, that it has expressed a range of market values instead of an opinion on a single market value. Is that correct?
Correct.
Okay. Now, why do you think your report was necessary when Mr. Hearn's report was in line with international recognized valuation standards?
Because, for the reason I've made clear in paragraph 511, that I believe whilst the methodology which he employed was in line with international valuation standards, there's one thing missing, which was an expression of the opinion of value as at the valuation date. Dr. Hearn provided a range. As a real estate valuer, I've become accustomed to the need to provide a single valuation at the date of valuation. And that is why I explained that I had to go further and provide an opinion at the date of valuation.
And we all know, obviously, that the figure is the most important, one of the most important things in evaluation, the number that you arrive at, right?
Yes.
And then you're saying actually that Dr. Hearn was not in compliance with international standards concerning the figure.
No,
but
I'm
you
saying,
still say that he was in compliance.
I'm saying that with the exception.
Yeah, but it's a quite big exception, I would submit to you.
Nevertheless, it's an exception. Having reviewed Dr. Hearn's report, I considered it that it was very well researched. The argumentation, I believed, was convincing, with the exception that Dr. Hearn provided a range, whereas as a real estate valuer, I'm accustomed to providing a single figure at the date of valuation. And that, I believe, is
we understand that.
figure.
But I'm just saying,
But I can't say
that's a big exception?
I can't say that because Dr. Hearn has provided a range that effectively it crosses out everything else and he's not compliant with international valuation standards.
Okay,
I'm saying that he was compliant with the exception that international valuation standards would require, under the definition of market value, a single figure.
Thank you. Now, would it surprise you if I tell you, actually would not surprise you because you have read his subsequent reports, that he still has not provided us with a single figure in his subsequent report?
Well, I'm not surprised by that because I, in effect, were instructed to provide a single figure. What instructions Dr. Hearn had in connection with his second report, I was not a party to.
Right.
So he would have complied with a set of instructions in arriving at his second report. So clearly, he may not have been instructed to arrive at a single figure. I suspect that's because the parties had already received such an opinion from me.
Right. Okay. Well, we don't know about that, and we'll see tomorrow. In your report, and that is, for example, paragraph 6.6, you chose not to rely on the Confinex report. Is that correct?
Yes.
Okay. Now, at paragraph 6.5 of your report, you say that the best valuation evidence of Dr. Hearn's lower bound are BD Agro's transactions of 20 to 23 euros. Is that correct? That's paragraph 6.5 of your report.
Yes, yes.
Okay?
I've taken a quote from Dr. Hearn's report.
But then immediately, in the one but next paragraph, paragraph 6.7, you quote, hasten to add, unquote, that they, quote unquote, carry little evidentiary weight because they are too old.
Yes.
Is that correct?
Oh, we're talking about comparable transactions which occurred 8 years ago or something like that. Was that right?
Exactly, exactly. Yeah. But these are the transactions that are mentioned in paragraph 6.5 of your report.
Yeah.
And then you hasten to add that they are too old. So
they are too old. They are too old for me to have had regard to in arriving at my single figure at the date of valuation.
Yes, correct. Yes. Okay. So you also disregard them as well. And then you quote Hearn in paragraph 6.4 of your report, a little bit before, and you quote what he defines as the basis for his lower bound valuation. And the first source is the Serbian tax authorities for calculating property taxes, and we will return to that in a second. And then he confirms this price that he arrived at as a lower bound by saying that it's quote-unquote broadly consistent with Confinex valuation and the evidence from BDA's transactions. Is that correct?
That's what he says, yes.
Okay. So we have just seen that you have effectively disregarded two of the three sources for Mr. Hearn's lower bound. You disregarded Confinex and you disregarded old BDA transactions. Is that correct?
That's correct, because...
Thank you. I mean, you explained that in your report, why.
Yeah.
And then what we are left with are the tax assessments, which Dr. Hearns calls the valuation of BD Agro's land as determined by the Serbian tax authorities.
Which paragraph am I?
That is paragraph 6.4 of your report, quoting paragraph 89 of Dr. Hearn's first report.
Yes, the
Yeah, please do read.
For calculating property
Yes.
taxes, yes.
And then actually these assessments of Serbian tax authorities for calculating property taxes, you don't deal there where you deal with the rest of Dr. Hearn's sources, you deal with them a little bit later. That is paragraph 613 of your report. Could you take a look at 613?
This is, yes, I see.
Okay. And it seems to me that you didn't want to be too hard on Dr. Hearn, so you didn't criticize him immediately, but like a couple of paragraphs afterwards. But that's only my impression. If one reads your analysis in 613, one concludes that these are first not valuations of BD Agro's land, as Mr. Hearn calls them, but what you call, quote, a mass appraisal without regard to the unique characteristics of individual properties.
Yeah.
End of quote. And then you say that this carries, quote unquote, a little evidentiary weight. Is that correct?
That's correct.
So you have effectively removed the third, or actually the main source of Dr. Hearn's lower bound valuation. So there is nothing left to support his lower bound price, I would suggest to you.
I'm not supporting Dr. Hearn's lower bound. I'm supporting my, having reviewed his valuation, I came to the opinion that he was entitled to come to the range of values that he did, but then moved further and said, well, in order to arrive at the figure, the single figure, the date of valuation, this is the evidence that I consider we should have regard to. And certainly, at that stage, I would have rejected tax assessments because I don't think they're relevant for arriving at a valuation at a single point in time.
Okay, clear. That was quite clear, but I would just remind you that you were tasked with to revine and opine on the expert report of Dr. Richard Hearn, and that is at the very beginning of your report. Yeah. So you revived, and this is why I'm asking you this.
Had he used that evidence to arrive at a single figure at the date of valuation, certainly I would have been tougher on him, in the sense that I would have said, well, he shouldn't have relied on that evidence, or that evidence at the date of valuation. As it is, I was opining on his range of values. And as such, I can understand why he applied the evidence that he did. But it's not the evidence that I would necessarily have relied upon in order to arrive at the single figure which I did.
Thank you. Well, our task was actually here to see how you reviewed Dr. Hearn's opinion, valuation. And so I wanted you to deal with the lower bound valuation and its sources. So I think that was clear enough that there is nothing left with. But let's go to the upper bound price of Mr. Hearn. And it is based on two sources. One is valuation by Mr. Murgood, and another are comparative transactions evidence. And I'm now looking just to your report to that is, I believe, paragraph 6.9. Okay. See that? So let's
Yes.
Yeah, let's see what is Mr. Murgood saying. Or actually, what are you saying about Mr. Murgood? Sorry. At paragraph 6.10, you say that Mr. Murgood's valuation, quote, might be criticized somewhat, end of quote, for being based on asking prices. But then you say it's a common practice among Serbian valuers, right?
Right.
Because it's difficult to obtain evidence elsewhere, right?
Right.
But first, let me ask you, is it really that difficult to seek for prices? Are you familiar with the fact that information on transactions, on the real estate transactions in Serbia is available on the internet through the Serbian Geodetic Authority?
Yeah.
Right?
Yes, I am familiar with that. I'm not sure that it's necessarily 100% accurate, but also I'm also aware that it is the common practice amongst Serbian valuers to use asking prices.
Right, but did Mr. Murgood consult the database of the Republic Cadastre or Republic Geodetic Authority?
No, he used the evidence of asking prices.
So he went straight to asking prices, correct?
I would assume so, yes.
Okay. Okay, so let's flip his report. That is CE 175. And if we can just go at the very beginning, let me say it's a 15-page report, it's relatively short. Can we go just at the very beginning of the report and just flip through it to see what is there? So there is introduction and then subject of valuation. Okay, further, and then there is a list of land, zoning, market characteristics. Okay, and then we stop at the method of valuation of land. Could you just, could we have the highlighted part from the procedure applied in the valuation, and then also the next paragraph of the, you have it on the screen highlighted,
Right.
if it's easier for you, okay? Now, I assume you have read Mr. Murgood's report when you were preparing for...
Originally, yes.
Yes, okay. Can you read this, and especially the second paragraph, and can you tell me, do you understand this?
We're talking about the sentence which begins, the comparative method was applied to the stock exchange data on trends in the market value. I assume that means the movement of market prices over a period of time.
But what is the stock exchange data? And I can assure you it's not a mistake in translation.
I would imagine that he had regard to statistics which maybe the stock exchange would have issued on trends. That
You
said,
think that there are such statistics in Serbia?
well, there are statistics in Serbia.
Yeah, they are, but
Yes.
is there actually a publication on the stock exchange dealing with the prices of real estate?
I don't know.
Okay, and you don't see a source for that?
I don't see a source for that, no.
And does it look somewhat strange that he
But-
refers to the stock exchange there?
I would say that in terms of his valuation itself, I would find that particular reference to stock exchange data on trends would not have affected the valuation itself.
Thank you. Now, okay, let's go to the main source that Mr. Murgood is using for his valuation, and that is the next section, 5.2. It's called comparative method. And if we can see the table, please, just the whole table on the screen. It's on the 2 pages, probably. Ah, cannot fit, yeah. Okay. Can you tell us what is the date of these are the advertisements, right? And for the selling of property. Can you tell us the dates of the advertisements that Mr. Murgood is referring to?
It doesn't seem that he's put the dates in. Or I can't see which column. There seem to be no dates.
So we don't know actually when these advertisements were placed. Could
No,
it
we
be
don't.
10 years ago, 5 years ago, 3 years ago? We don't know that, okay?
Right.
All right. If we can go now to Exhibit CE 512. And go to page 28. And if you can please highlight the standard 5.6.1. 5.6.1. And I think that this is quite familiar to you, I would say. This is the discussion of the valuation date. And it says that should reflect the valuation amount will reflect the actual market state and circumstances at the effective valuation date, not at the past or future date. Does it say that?
Yeah.
So we would say that Mr. Murgood's transactions are of quite limited use because we don't have any idea about the time when these advertisements were posted, correct?
That's correct. I mean, I
Okay.
can only assume that because he was instructed to value in 2015, that he would have relied on evidence from around that time.
But you assume that, you
I
don't know
assume
that.
I don't know that.
Okay, can we go back to Mr. Murgood's report, please? Thank you. Now, Mr. Gretchek, you see these 5 transactions and this table. And can you, I mean, are you not a little bit concerned that it is on the basis of this undated small table that Mr. Murgood comes up with a valuation of no less than 87 million euros for the land in zone ABC? Don't you think that we would, or one who would read that, would deserve something more to accept this amount, this figure, as reliable one?
Well, certainly, if you're relying on asking prices, then as much information as possible is needed, because asking prices are the lowest level of evidence that you can use in evaluation.
Thank you. Now, so this was one of the sources of Mr. Hearn's upper bound price and the main source.
Yeah.
Now, Mr. Hearn also says that his upper bound price is consistent with his comparable transactions evidence. And if we go to Hearn first report, paragraph 64, table 3.3, we will see what he provides there. A little bit down. Okay. So this is what he provides. You have seen that, obviously. These are transactions spanning for like 6 years, and the price is spanning from 15 to 88 euros. So it is hard to figure out where is the consistency between Mr. Murgo's report on the one hand and this range of prices that Mr. Hearn evokes. Is that correct?
Well, it's not the way you're presenting it, because it's not 15 to 88. It's different ranges in different years. So, for example, when we look at the range is 15 to 23, which is the transactions in 2008 and 2009, and then the 88 falls within the range 2012, 2014 Zeman transactions. And of course, Zeman is a different area. So they won't necessarily be comparable.
If we look at Pazova transactions and Batanica market value assessment, that is from 2013 to 2016, which is quite around the valuation date. And the range is still from 20 to 37 euros.
28 to 37, yes.
No, 20 to 37. Pazova transactions lower bound is 20. So you have still a range which is about relatively wide, right?
Yes. This is all the evidence upon which this is but this is the evidence that Mr. Hearn put into his research, the pot. So it's all there, and from that he made certain deductions about his lower bound and his upper bound. So it's not as if he, for example, relied on Zeman transactions at 88. This is simply the accumulation of all the evidence that was there for him to analyze and to consider. So it's not as if he's having to find a value between 15 and 88.
Well,
These are all different ranges depending on the areas and the dates.
Mr. Gretchek, I'll put to you that you are a very charitable interpreter of his report. Let's go see what the report says, and if we can look at paragraph 89, point B of Mr. Hearn's report, where he says or sets out the sources of his upper bound price, and he said the upper bound of 30 euro per square meters is based on the weighted average price used in Mr. Murgo's valuation. Okay, we know that. And then he says it is also consistent with the comparable transactions evidence, which ranges from 20 to 37 euro per square meter.
Yes.
So I put to you that this includes both Pazova and Batanica transactions, because this is the range exactly from both Batanica and Pazova transactions.
Well,
so it's not much of a it's not much of a consistency because it's such a wide range. Would you agree?
It's a wide range, but
Thank you.
that is also the view of Dr. Hearn.
Yeah. Okay, so now let's move to your report and to what you call highly relevant assessments of land in Batanica, and you have mentioned that today. Now, if we move to paragraph 612 of your report, okay, you say that they are highly relevant there. We have done that. Okay, 614, sorry. You provide two main reasons, if I may summarize your point of view, and probably that was, I think that it was also today's in your presentation. You provide two reasons why you find these Batanica assessments to be relevant and to be taken into and to be basis for the valuation. One reason is that they are close to the valuation date, and another reason is that the sites in Batanica are a similar distance from Belgrade zones A, B, and C, and other things are also relatively equal.
Yeah.
Is that a fair?
More or less, yes.
Okay.
I mean, and I'm not saying exactly equidistant.
Sure, they cannot be exactly, yes. Okay, let's start with this last point. At paragraph 616, you say that both Zone ABC and the Batajnica have, quote, all requirement development plans in place. Is that correct?
Yes.
And then in a footnote, you refer to CE 521. That is the detailed regulation plan for Batajnica.
Yeah.
And then to CE 143, that is a general regulation plan for ABC
Yes.
zone. And you say that you have read both of these plans in your, at the beginning of your report.
When I did my report.
You did. Have you read them recently, perhaps?
Not recently, but I read them during the report stage.
Okay. Are you familiar with the differences between detailed regulation plans and general regulations regulation plans in Serbia?
Well, I'm not a planning expert, I'm not a construction expert, but my understanding is that where you have a detailed regulation plan, in some instances you then require, when you have a general plan, in some instances you then require to provide a detailed regulation. And in particular when you require provision of infrastructure and those sort of elements. So that there is a difference, yes.
There is a difference, and the general plan needs to be sort of a little bit specified, implemented through a detailed regulation plan. Is that what you're saying?
My understanding is this, that if you have a general regulation plan, there may be, in certain respects, the need to provide a more detailed regulation plan, and that detailed regulation plan can be provided for by the investor. But I don't see, well, there is a difference, but I don't see a huge difference in terms of assessing the value of the properties, whether the additional requirement of a detailed regulation.
Do you agree that there is that a certain period of time is necessary to have the detail, if there is a general plan?
Yeah.
So there is a certain amount of time that is necessary to develop a detailed plan and to adopt it.
Indeed, and I think that this certain period of time would coincide, if you imagine that you have an investor purchasing the site, and then particularly sites without infrastructure, they will then need perhaps several years in order to work up all sorts of things, such as the architectural plans, the detailed regulations, and that would all coincide in the same period. So I don't see too much of a disadvantage where you don't have that detailed regulation plan.
And then obviously the investor may be suggesting the detailed plan, but it is adopted by the authorities.
Yes.
So you have to wait.
But the
Madam President, I object. Now we are getting into areas of several misrepresentations made by Council for Serbia. These questions also relate to Serbian regulation of construction, which is not the area of expertise of Mr. Gretchek. And just to tell you what the misrepresentation is, that it's been constantly suggesting by Council for Serbia that there was a need for a detailed regulation plan in the area regulated by the general regulation plan in Dobanovce, which, as Council for Serbia knows, is contested by the claimants.
Exactly, I know, but I would just say that Mr. Gretchek is saying at paragraph 6.16 of his report that both locations have, quote, all required development plans in place, and then he quotes these two. And my question was to compare these two and to see whether that is on the same level of, whether they are the same, and whether they are all required. So the expert is saying that it's all required regulations are in place. And I'm testing that assertion, so there is nothing misleading there.
No, it's in the questions you are asking, because you know very well that the position is that from the perspective of Serbian law, a general regulation plan and a detailed regulation plan are equivalent in the sense that this is all which is needed for construction of these pieces, on these pieces of land.
Yeah, I must say that I had questions on this because it was unclear to me in what stage the land was in terms of development and what else was needed and how much time this would take. Now, either you're familiar with these topics and then you can give me some explanations, or you're not familiar and then we don't ask you, and it's no problem because you're a valuation expert here.
I think what I can say is that the zones A, B, and C were under the regulation plan. That was land which is suitable for the development of industrial and business uses. However, in order to get to those uses, a lot more work needs to be done in terms of provision of infrastructure, in terms of provision of roads, in terms of the whole planning procedure. So any developer buying this site would be fully aware of the enormous amount of work that still needed to be done to enable these sites to be put in a situation where you can start development. And this is the same for, it took several years in Batajnica to get to the point where today they can start developing. And equally, anyone who bought zones A, B, and C at the date of valuation would be aware that, you know, this is not something that tomorrow you can bring in the diggers and start developing. No, you need to go through a lot of planning procedures need to be put in place. You need to you need to get architects, engineers, infrastructure, and only when I talk about what's permissible, at this stage I'm talking about what the land is zoned for. So any developer buying zones A, B, and C would know, well, eventually I will be able to put up a logistics center here, offices or whatever, but not at the date I buy them. And that, I believe, is the same position in all the comparables that have been relied upon in this case.
So in other words, you say that this is reflected in the price. I think you said so expressly in your presentation.
Counsel for the respondents showed a table showing Zermin, yes, Zermin? At 80,
yes.
At 88. Well, there we see sites which are far more advanced in the development stage, hence the larger figure of 88. So what we're dealing with here are sites which have a long way to go before they can become developed.
Thank you, that's clear.
Thank you. Okay, let's compare the sites further. At paragraph 616, you also say that the expropriated sites, that is Batajnica, are close to the Belgrade bypass. While they are close to the Belgrade bypass, they are not connected to it and lack connection to any main services, correct?
Yes.
And this is actually almost verbatim of what Mr. Markicevic says at his third witness statement at paragraph 105. And you actually, I think, quote Mr. Markicevic to that effect. But let's see what Mr. Markicevic says. You have read his statement, I assume. Right?
I haven't read his statement, but a lot of the information I know, factual information, upon which our reports are based, comes from much of the work that he did on the ground.
Sure, but Mr. Markicevic is not a real estate expert. He's a witness.
But I rely on the factual research that has been carried out.
Yeah. Are you aware that Mr. Markicevic is in the management of one of the claimants, a director in one of the claimants?
Yes.
Okay. Now, can we look at paragraph 105? and the sentence is highlighted, and we don't see any source for this statement, right? Okay, can we move back to your paragraph 617 or 617 or 617? There's the next paragraph, and you say you take up the same theme, but you change the wording a little bit about Batajnica plots. And if you see, it's a first sentence, you say that they are well away from any road except for dirt access roads for agricultural vehicles. See that?
This is 617, yes.
617 ending with footnote 55. And in the footnote 55, you again refer to Mr. Markicevic, paragraph 106.
Mm-hmm.
Can we see Mr. Markicevic? Paragraph 106, it's almost verbatim, a little bit changed. And also we don't see any footnote there, any source there, right?
Yep.
So he does not provide any footnote, any reference, or any photograph or documentary material, is that correct?
Well, I have relied on his evidence insofar as his factual fact-finding for the purposes of this valuation. Much of the groundwork has been carried out by him.
Sure. So you, as a valuer, rely on the groundwork and factual research done by the person who basically commissioned your work or your evaluation.
Well, I was commissioned by counsel.
Okay, who were commissioned by the claimants.
Okay. But I treated all that, I found it was a very detailed amount of research which was undertaken, and there was no reason for me not to rely on that.
Okay. Let's go at paragraph 6.17. Last sentence, which says, additionally, zones A, B, and C are considerably closer in proximity to the E70 highway than the Batajnica land plots.
Yep.
And then in footnote 56, again, reference to Mr. Markicevic.
Yeah.
Can we see Mr. Markicevic? Thank you. 107. And actually, Mr. Markicevic is at 107 providing a map and not a statement. And so you relied on the map, or you relied on his
Well,
statement?
you can see, if you look at the map below, you can see where the Belgrade bypass is, and where you can also see where the E70 highway is, just to the north of Zone A. And so that's a factual statement that...
Sure. But let me just tell you that actually what you were transferring verbatim from his statement is paragraph 107. So it's verbally also. Put verbally at paragraph 107, what I just have said. But let's look at the map. Or actually, let's look at what Mr. Markicevic is saying at 107, and whether... no, there is, it says 106, sorry. Considerably closer to the E70 highway than the Batajnica land plots. And again, no source. And then you have a map, okay. Mm-hmm. Let's look at the map. So let's remind us, upper map is Batajnica, lower map is Batajnica and zone ABC aerial view, right? Now, you say that ABC zone is considerably closer than Batajnica land to highway E70. That is true. Everyone who lives in this part of the world, in this city, knows that where is highway E70, and it's where you put it. It's on the screen. There's an inscription on the screen. But Mr. Gretchek, is there another highway
Well, I've referred to the Belgrade bypass, I've referred to the E70, I've also referred to the planned Sremska Gazela road. So you have to help me if there's another highway.
There is the famous Europe route called E75, which goes north-south. And Belgrade bypass is part of that route. So it's actually a highway. And if you are not correct, you can look at Mr. Hearn's first report, paragraph 69, and he confirms that there.
Okay.
So, yeah, you see the last sentence of Dr. Hearn's paragraph 69. Patenica region lies next to the E75 road, while BD Agro would have to rely on the Sremska Gazela, which obviously has not been constructed. Now, if we go back to the map, please. So it does not seem that Batajnica is, quote, well away from any roads, unquote, as Mr. Markicevic says, and you accept, so to say, uncritically. You can even say see on this photograph, you can see the highway. You can even see the cars on the highway, okay?
Except
now let's take a look at the lower part, at the zone ABC. Does it not appear to you that the E70 highway that you mentioned is relatively further from zone ABC than the highway E75, which is right next to Batajnica land?
It is further away.
Thank you very much. Now, have you visited the Batajnica plots?
What I did is, when I did the tour of the zones A, B, and C, we also did a tour of the surrounding area, including Batajnica.
Right, but you have not noticed this that we today have discussed. That is just right next to the highway.
Well, obviously I would have noticed that, but we didn't go on to the actual plots themselves, but toured the area.
Okay, thank you. Okay, let's move then to paragraph 69 of Dr. Hearn's report. We have already seen that. You see this sentence that we have already mentioned as evidence so that Batajnica region is next to E75. And you see how it's formulated and with the however, and there is a clear reservation by Mr. Hearn that BD Agro would have to rely on the Sremska Gazela for a connection.
Yep.
See that? And then you, nevertheless, having studied Dr. Hearn's report and Mr. Markicevic's statement, you chose to rely on Mr. Markicevic, correct?
Well, it's not that I didn't rely on anything which Dr. Hearn said. I simply inserted that as a statement of fact.
Thank you. Okay, now let's consider your second reason why you find Batajnica land assessments as the best evidence, in your view, in support of valuation of zones ABC. At paragraph 615 of your report, you state that, quote, the assessments of the value of the Batajnica properties were completed by the Serbian Tax Authority in November 2015 and are close in time to the valuation date of zones ABC of 21st October 2015. Is that correct?
That's correct.
Now, in this regard, you refer in a footnote 51, which is attached to this statement, you refer to Mr. Hearn's first report, paragraph 71. Okay?
Yep.
And if we go to Mr. Hearn's first report, paragraph 71, you will actually see that in paragraph 71, Mr. Hearn writes about what you call mass appraisals of land that you have rejected as a valuable evidence, etc. Is that correct?
That's correct, yes.
So the footnote is wrong, right?
The reference to November 2005, I must admit, may have been incorrect, because that November 2015, I think, actually does relate to the mass appraisals.
Yeah.
So there I would admit that perhaps the November 2015 date is not precise.
Okay, and it's a completely different evidence, right?
It's
not
it's not mass appraisal.
okay.
It's valuations for expropriation.
Right. And can we go now back to Mr. Gretchek's report? Do I pronounce your name?
Grzeszek's fine.
Gretchek, right?
right.
Okay, thank you. Now, at paragraph 615, you said the assessments of the value of Batman's property were completed by the Serbian tax authority in November 2015 and are close in time to the valuation date. So November 2015 should be stricken out, right? Am I correct?
I think, to be safe, yes.
Okay. Now, let's look at the real underlying source of the Batenica tax assessments with the help of Mr. Hearn's first report. That is at paragraph 64, table 3.3 of Mr. Hearn's first report. But it's a big table. Maybe we could go, that's just for the reference, we can go to paragraph 191 of his report, where he develops, in an annex, develops his analysis. And there, 191. There, Mr. Hearn refers in a footnote to 3 exhibits. That is CE 159, CE 160, and CE 161. And if you can take a look at these exhibits in your bundle. And my colleague will prepare them for you.
Mm-hmm. Okay, got CE 159.
159, 160, and 161. This is what you call the best evidence.
In the context of all the evidence.
In the context of, but that is the evidence for the Batenica transactions.
Yes,
Can you confirm?
it's the best evidence in the context of the evidence available.
Thank you. Can you confirm the dates of these assessments?
So we have this, we look at CE 159 is March 17, 2016.
Okay.
June the 8th, 2016.
Thank you.
And August 26, 2016.
Right. Mr. Gretchek, how do we know when these assessments were made? Have they been made at the dates that are on the documents?
No, they would have been ready by the dates in the document. But what I in my evidence, what I said is that the assessments, which albeit they were made in 2016, would almost certainly have had regard to evidence, market evidence, in 2015, perhaps 2014.
Are you sure?
As as an experienced valuer, I would suggest that almost certainly amongst the comparables that the tax assessors would have had regard to, they would have looked at what was happening in 2015, unless they may have had some fresh evidence in 2016. I don't know, but I'm
so
just...
if you make an assessment, if you draft a document like this and you're a Serbian tax authority, and you do it in August, that is 8 months into a year.
Mm-hmm. But if
that's
I'm
a lot,
valuing,
right?
Let's suppose I'm valuing in August 2016, almost certainly I would look to bearing in mind comparable evidence is not easy to find, so you try and make the most of the evidence you can find, let's say, in the last 2 years.
Yeah, but this is what you would do as an independent valuer.
And
And
I
this
think-
is Serbian tax authorities that make their assessment. And do we know how do they make their assessment?
Well, they're obliged to arrive at the market value. That's
Right.
stated in the law.
Exactly.
So-
But do we know actually how they actually made this assessment, let's say in August 2016?
I would assume that they would follow the procedures for undertaking a valuation to arrive at a market value, and that they would be competent in doing so, and that they would rely, I would imagine that they would rely on historic evidence.
Right, but you don't know what exact
I don't know
historic
what
evidence?
No, I don't know exactly.
And you don't know actual time of the transactions that they used for
No.
their assessment?
No.
Thank you. Now, if we can go back to Exhibit CE 512. And if we can remind ourselves what it says. Remember what we said here at 5.6.1, Mr. Gretchek. Quote, the valuation amount will reflect the actual market state and circumstances at the effective valuation date, not at the past or future date.
Yeah.
Correct?
The valuation will reflect the actual market state and circumstances at the effective valuation date.
Okay.
Yeah.
Sorry, just give me a sec. And if we can go to page 56 of the same document, it's also a standard. It's called Supporting the Valuation. And it says, second sentence, quote, the quality of the valuation will, in part, rely on the quality of the information used to prepare it. And so the valuer will need to verify any sources and the date of that information. Is that what the standard says?
Yes.
Thank you. Let's move to the bankruptcy proceedings that you also commented upon in your report. And you compare the bankruptcy sale, the sale in the bankruptcy proceedings with the market sale, correct?
Yeah.
Okay. And at paragraph 16.23 of your report, you summarize what you say were the flaws of the actual bankruptcy proceedings, correct?
Yeah, the summary, yes, on the table. Yes.
It's a summary. And again, I note you refer to Mr. Markicevich's third witness statement. Is that correct?
Can you, this is footnote 119, yes? And
Okay. And then, on the basis of what Mr. Markicevic says, you make conclusions such as that this type of process of sale would attract, quote, disbelief and suspicion.
That's my quote.
Yeah, that's exactly. And then you, but you on the basis of Mr. Markicevic's evidence, right? And
No,
then you say it creates perception, quote unquote.
On the basis of the whole process, which I've outlined in my report about the proper marketing process, when you go through paragraph by paragraph of all the shortcomings of the bankruptcy proceedings, you can't fail to conclude what I've concluded at the end. So that's entirely my own view.
But did you independently check what Mr. Markicevic states at paragraphs 131 to 134 of his third witness statement to which you refer?
At the time, I would have done so.
You have independently checked that. Are you confirming that?
All the material in the footnotes I would have checked at the time of writing this report. I haven't gone
but
back
it's
to
not
it.
my question. Maybe I was not precise enough. Sorry for that. I understand that you have read Mr. Markićević's statement at the time you wrote your report, but did you check the actual factual allegations made by Mr. Marković?
I didn't.
Markićević.
I would have treated them in good faith.
Okay, and you consider yourself a bit of an expert of Serbian real estate.
Well,
Could we say that?
I wouldn't.
You
describe
spent some
myself-
time there.
I wouldn't describe myself a bit of an expert.
You were an expert then.
I would describe myself as being knowledgeable on valuation practice in Serbia.
Okay,
And-
great, thank you. Now, at paragraph 134 of his third witness statement, Mr. Markićević complains that there was a strike of the cadastre of the land registration, and he could not check the ownership of the land. See that?
Yes.
And you then refer to that. Now, are you familiar with the fact that in Serbia, ownership can be easily checked on the internet site of the cadastre office?
I'm familiar with that, yes.
So does this sound credible for you that Mr. Markićević says, well, I could not do anything, everything was closed?
Yeah.
He even
This is
puts up a picture there.
objection. This is a misrepresentation of Mr. Markićević's testimony. He didn't say he could
Okay, I
not do
can
anything.
quote Mr. Markićević's
I think
testimony. I
what-
just want Council Proclaimer not now to give an answer for Mr. Gretchek because he did that last time. Thank you.
I think what matters for us is to what extent, when you refer to Mr. Markićević, you have checked not only what Mr. Markićević himself expresses, but also the facts which he alleges.
In terms of the facts of the bankruptcy proceedings, the auction, then I didn't carry out any verification work myself. I relied on the information that I was provided with, and then drew conclusions from the process on the basis of the evidence that I saw before me.
As it was
I didn't
described
verify.
to you.
Yes.
Yes. And with respect to the cadastre, you said before that you know that you can check ownership online. Is that
Yes,
what you said?
yes, but I didn't do so in this case because I was asked to opine on the process of marketing rather than having to verify the various facts presented in the procedure.
That's
So
clear.
I didn't see that as being down to part of my role.
Thank you.
Thank you, Madam President. I have no further questions.
Good, thank you.
Thank you, Madam President. Yeah. Mr. Gretchek, let's just follow up on this last topic. Do you know, Mr. Gretchek, whether the information included in the online version of the Serbian land cadastre is legally binding?
That I can't answer that. But I suspect if it's...
I'm sorry, the witness's microphone is off. Could the witness please switch his microphone back on?
Sorry.
Thank you. Please, could you go back to the beginning of your answer?
Whether it's legally binding or not, that I can't answer that question.
Do you know how often the online version of the information is updated?
From experience in other countries, I would imagine several months.
Do you know, Mr. Gretchek, whether it is customary that a buyer of real estate in Serbia would rely on the online version or would go for the actual extract from the cadastre in paper form?
I think in carrying out his due diligence on such a complex land, he wouldn't rely on the internet.
Mr. Gretchek, do you still have your presentation in front of you?
Yes.
Could we please go to the map of the Batajnica land? Could you please, because you were asked, I believe, about the expropriations which are marked in red, correct?
Yes.
You were not asked about these which are marked in blue, correct?
No.
Could you please comment on these which are marked in blue?
Well, as you know, I mentioned that I derived my evidence on the basis of the 2016 valuations for expropriations. But as a fallback, I've also, in this, on this aerial view, shown the sites expropriated in 2013, or certainly valued for expropriation in 2013. And I would suggest they show a figure of 27 euro per square metre, which seems to be consistent with what was happening several years later. And so I think certainly as a fallback, there is this evidence of the 2013 valuations.
No, this is what we are shown on screen is not the picture that commented.
I understand we're looking at the presentation, page 5, and I think you did mention during your presentation that the blue values confirmed your finding from the red ones.
Yes, they set a floor because, of course, I valued at 30, and I believe that if 30 in 2015 is right, even if one has regard to 27 in 2013.
Yeah. Now, if we look at, for example, the one red land plot marked at 37 euros per square meter, in the middle, more or less, of
37 euros. Yeah.
Yeah. Does it appear to be connected to an existing road?
It doesn't seem to be connected to an existing road. I'm not sure about whether there are dirt tracks there or field roads. Bearing in mind it's agricultural land.
Mm-hmm. Does that piece of land...
But the acquisition, the blue line do suggest that these plots are being acquired for road building.
And then do these land plots seem to have connection to services?
No, not as far as I'm aware.
Now I would like you to comment on the detailed regulation plan for Batajnica. Yep. It's CE 521. Could we please have it on the screen, 521? At the beginning of the document, 521, beginning of the document.
CE 521, I have this.
Ah. Okay, we will do that. Yeah. Oh, we have it. Okay, thank you. So what is the date of this document?
June, 23rd June 2015.
Yeah. So that would be after the 2013 expropriations, correct?
Yes.
And now I would ask you to go to, on the second page of the English translation, sorry. We have point 3, legal and planning basis there. Could you please tell me whether there is any general regulation plan included?
This is starting with legal and planning basis,
correct.
Yes? So we have this part of...
Is there any general regulation plan
extract
listed?
From comprehensive plan for Belgrade Forms Plan, general regulation plan. I'm trying to... I don't see one.
Thank you. No further questions, Madam President.
Thank you. Any questions on your side? No? Yes, please.
So, thank you, Madam President. Dzień dobry.
Dzień dobry.
In your presentation, you put on screen a table of transaction prices of comparable properties rejected by Ms. Illich.
Yes.
There were two items on Surchin Dovanovci, and the second one, it is mentioned adjacent to BD Agro.
Yes.
Did you try to locate?
Yes, we've got the
exact
location. I think it's in one of the exhibits. The location of that plot is shown.
Do you remember which one?
Do you know it?
We will try to find the exhibit and put it on the screen.
Okay. If you remember, and we take the photograph map you put also on the screen.
This is slide 5, yes?
Where this is.
Yeah.
So we are now showing RE 540. If you prefer to have this on the screen, we can put it on the screen as well.
Yes, why not?
So you prefer we look at the map, or?
I would like to ask Mr. Gretchek if he can identify in the map.
I think we need a bigger. This is a better scale.
If this is better.
Yeah. And you can see the two locations are identified, and the location adjacent to the farm you can see on the left-hand side. And it joins the BD Agro land farm.
Yeah.
I'm sorry, maybe I missed something, but have we identified this map?
This is from RE 540.
RE 540, and does it have a number? Was it RE 540?
Yeah, this is Respondents Exhibit RE 540.
It's just the map.
No, it's
a long document. Yeah.
Information from real estate price register.
Good. So it is. Are there? Now, my question was unclear. Are there other maps in this document, and then we need to identify it?
Okay, so it's on page 3 of this document.
Page 3. Yeah. Thank you.
Okay. Thank you, Madam President.
Mr. Gretchek, Mrs. Illich makes a number of comments on the basis for your valuations, but I think they go more to Mr. Hearn's report in the end because than to yours, so I'm not going into those. Let me just ask one question. Looking at your report about the valuation of the agricultural land in 10.1, so you took Mr. Hearn's range and then you narrowed it down, but then somehow you were stuck, if I understand it correctly, at a range from 0.8 to 2.9, and then you just took the middle of these figures. I was asking myself whether that is a proper valuation
I think
process to just split the difference in half, because it looks a
well,
little
it looks like that.
arbitrary to me.
The problem here is the valuation of agricultural land is actually very problematic, because I think both myself and both Daniela Illich found that there's a huge range, as indeed shown here. And so the question then is, what do you do? with that huge range. And unless you look at each specific comparable sale and analyze each one individually, it's very difficult to come to conclusion, well, what is the value? And this is why I suppose I've taken the easy way out. I've taken the midpoint. But in all honesty, I couldn't think of any other way of finding the acceptable value there. It's not, I accept it's not ideal, but unusually here, the ranges of agricultural values, even the ones that Daniela Ilic has, are quite substantial. And it's very difficult for any valuer to make sense of that. So this is why I've taken the midpoint on this.
Is this an approach that other valuers would share?
I think it will be a similar approach that other valuers have taken. I've taken effectively the average. Daniela Ilic has taken what she calls the median. And I would certainly criticize her use of the median because, coming back to my definition of market value and the interpretation of market value is the best price reasonably obtained in the market. Now, the best price reasonably obtained in the market is certainly not a median, and it's not necessarily an average. But when a valuer is faced with a number of what he calls comparable properties, and they have a relatively wide range, if he can't understand why that range is so wide, typically the valuers will resort to the average, and this is what I've done here. But I agree, it's not.
And that is, and you rule out the median because you think it's wrong to exclude the extremes, or is that?
Well, no, I think when you apply averages, you do look at the range of comparables and ask yourself, well, are there any comparables in this packet, in this database, which are so extreme, one way or another, that actually they don't fall within the pattern? So you do reject them, and then you arrive at an average. I think if you look at Daniela Ilic has arrived at 6.3 million on the basis of median. Now, if you actually look at her average prices, take her calculations of averages, and had she employed averages, she would have arrived at over 12 million euro. So the difference between using a median and an average is 6 million. And I don't have an answer to this. It is very problematic. The evidence is so diverse that I'm afraid the best I could do in the circumstances is take the average. But then again, when you look at the range, which is from 0.8 to over 3 or 4 or 5 euro, then I don't think a figure of below 2 euro a square meter seems excessive in the circumstances. But this is the part of the report which I found most problematic.
Thank you. No clarifications?
No, Madam President.
Then thank you very much,
Thank
Mr. Gretchek, for your answers. This completes your examination.
Thank you.
And we can now take a lunch break until 1:30. Is that fine?
This is fine.
Good.
sednemo ovde. Stvari sa strane da vam ne smetaju.
So you will have cross-examination bundles here. I can put it next to me. You know what, because you should go there only after she finishes her presentation, so just keep them with you. And these remaining ones, let's put them somewhere here.
Da, ovdje ćete vidjeti prezentaciju. Da.
Cheers.
I will also use the same computer.
Very good. Okay, so you will have this here. Full copies. You see numbers. Number of what this one is?
Here, two bits are missing because they are in the other one. Stavim da ste vidite.
Da.
Good afternoon, Mrs. Ilic.
Good afternoon, Ms. President.
Oh, you will testify in Serbian, right?
Tako je.
Yes, right.
So now I'm ready. Can you please confirm to us that you're Daniela Ilic?
Da.
Yes, I can.
You are engaged in two valuation companies. One is Rufo and the other one is a Millennial Consultancy. Is that right?
Da.
Yes, that's right.
I'm sorry, this is the court reporter. I'm not getting the interpretation on the interpretation channel in Zoom. Could the technicians check that it is on the right channel? It looks to be transmitted on this. Thank you. That's it. Okay.
Fine.
Thank you. Please
the two
continue.
answers were yes so far.
Thank you. I'll make sure the record reflects that.
Thank you. You have provided us with two.
Vi ste dali, odnosno dostavili dva izvještaja vještaka.
Interpreters, that came through on the English channel.
Yeah. You have to switch channel.
Sorry. Thanks.
Good. It's two expert reports. This arbitration, the first one of 23rd of January 2020, and the second one of 16th March 2020.
Da.
Yes, that's right.
You're heard as an expert witness, and you know that I will now ask you to read the expert declaration into the record. It should be on your on the table in front of you.
Okay.
Svečano izjavljujem po svojoj časti i savesti da će moj iskaz biti u skladu sa mojim iskrenim uverenjima.
We didn't get the interpretation.
I apologize. I read it on the Serbian channel. Sorry.
Solemnly declared that you will make only statements in accordance with your sincere belief. Is that right?
Da.
That's right.
Good. Then I'll turn first to Mr. Jerish.
Thank you, Madam
Please.
President. Mrs. Ilic will have a presentation, so I will leave the floor to Mrs. Ilic. And she will obviously have a PowerPoint presentation as well. Thank you.
Hvala.
Thank you. Good afternoon, Madam President, and all of you present here. Once again, my name is Daniela Ilic. I'm a professional valuer and an advisor in the area of real estate. The two reports that I made, that we just mentioned, had as their main topics an analysis and critical analysis of the valuation made by Dr. Herrn that concerned the valuation of land of BD Agro, and second, an analysis and critical commentary of Mr. Gretchek's valuation. My second task was to give my own valuation as of 21st October 2015, and in the presentation to follow when I speak of the date of valuation, that will be that date. My presentation today consists of two parts. In the first part, I will briefly present my valuation, the methods I used, with a focus on the sources of market information that I used. And in the second part, I will comment on the key disagreements between my reports and those by Dr. Herrn and Mr. Gretchek. To start with my valuation, for the purposes of valuation and in order to determine the cadastral parcels owned by BD Agro on the date of valuation, I used the documentation submitted, among other things, the valuation reports by other persons, primarily relying on the Confinex report of December 2015. After that, I carried out an inspection on 20th December 2019, wherever I had access from a public road. Although my reports were made in 2020 and the effective date of valuation is 2015, and inspection was necessary in order for the valuer to get acquainted with the subject of valuation, with the location and the environment. After that, I identified the real estate by first identifying the type of land in question, whether it was construction, agricultural, or forest land. Then I read the ownership from the documentation that was available and identified the size of the parcels in each of the cadastral municipalities. I also used e-cadaster to get information on the size of the parcels, and I cross-checked the information, all the information available in the valuations made by other persons, because they did valuations before the date of 21st October 2015. And Confinex, for instance, in their report of December 2015, said that they had access to all the lists of real estate from the cadaster before the valuation date, and they also had a list of the main assets that included the cadastral parcels owned by BD Agro. In order to identify the size, the area in zones A, B, C, given that those are also parts of the parcels included in this zone. The zone doesn't always include entire parcels, but also their parts. I also used the detailed regulation plan, both its textual and graphic parts, precisely for the reason that parts were included there. I also used the portal Serbia, which is a public service. That's the geographic information system for the purpose of management of spatial data. That's a satellite image of a space where digital techniques were used to include the boundaries of parcels. Serbia also has tools that are available, and that is drawing lines and measurement of lengths and drawing and measurement of polygons on this very portal, which is what I used. eCadastre is a public service, publicly accessible service, and anyone can get access there to data on land and structures. I have to stress that it's sometimes updated on a daily basis, something on a 3-day basis, and sometimes it might happen that it's a longer period. In this case, for instance, it would be extremely unpractical and very expensive to use lists of real estate that came printed out from the cadastre, because that's a time-consuming and expensive process. I would like to stress here that the information in eCadastre corresponds to the printed information from the cadastre to 99%. I know this from my experience. When you work for banks, before we go to the location, we read it out from the cadastre, and only after we do an inspection, we receive a copy of the list from the client. In my professional experience, it's never happened that those don't coincide. I transferred the boundaries from the graphic part of the detailed regulation plan to the portal of Serbia. Given the limited time, I will not describe this in detail, but here on the slides you can see, and you can also see it in my second expert report, an exact description of how I did this work. But of course I'm at your disposal for any questions regarding the technique of measurement. When it comes to the valuation approach, I used the comparable approach, that is the market approach as it is called in International Valuation Standards, IVS. It gives an indication of value by comparing the subject asset or land with identical or similar land for which price information is available. So recent transactions. If we don't have such information, then the second choice of a valuer in line with the IVS standards are advertised prices. Of course, I use both where necessary, and I made adequate adjustments. There are no two identical pieces of real estate. So in our work, when using the comparable approach, adjustments are necessary. In order to value a large number of cadastral parcels, that's a portfolio of cadastral parcels in each of the cadastral municipalities, I assumed that the value of the portfolio is equal to a sum of the values of individual parcels. And in order to be more efficient in valuation and what's common in valuation of a portfolio, I prepared representative samples. When preparing the representative samples for each of the cadastral municipalities, I had a list of the parcels owned by BD Agro on the valuation date. I looked at the sizes and classes, that is, types of land in each of the cadastral municipalities. I calculated the median of the area and the scope of the class for each of the cadastral municipalities, and this is how I got a representative sample. Further, I researched the historical information on the prices, because this is the first choice of a valuer when doing the comparable approach, and those are the prices of transactions. For this, I used the database of the Republican Geodetic Authority, and when that wasn't available, when it didn't exist, or where I considered them inadequate, then I turned to advertised prices. The difference between the representative sample of the BD agro land and the representative sample of land that was advertised or subject to transaction, I adjusted through the price of the representative sample of the land that was sold. When it comes to the valuation of construction land in Dobanovci, first of all, I researched the database of the Republic Geodetic Authority, and in the period 2014 to 2015, there were only 13 sales that were registered. I have to say that the authority has to enter all the agreements on sale. There were only 13 of those. There were advertised prices in that period, so there was more supply than there were transactions in Dobanovci at the time. Of all the transactions that were registered, I eliminated 11 cases of sale for several reasons. Some of the reasons were that the location was not comparable to the land owned by BD Agro. Then some of them happened after the valuation date. But I have to stress that all the 11 of those that I eliminated, I believe that they were quite a lot below my final valuated or my final valuation. You'll see it in my first report, and I saw that that map was shown just a while ago. I looked at the other two transactions and concluded that in terms of the location and infrastructure, and in terms of access from the road, they were not appropriate to be compared to the BD Agro land in Dobanovci, especially in the zones ABC. Then I looked at advertised prices and looked at ads from 2013, 2014, and 2015. I paid attention to the description of the land that was advertised to be sold and paid attention to it being sufficiently comparable to the case of BD Agro Dobanovci. I looked at construction land and agricultural land in the construction and industrial zones. Since those were advertised prices and not realized transactions, at the very beginning I had a 10% downward correction, given that the willingness of the seller to negotiate the sale. And then I prepared a representative sample of the BD Agro land and got the median size and also the representative sample of the asking prices, and I got the median size of the area and then the median price. By comparing two representative samples, I made a correction of 30% downward in order to reflect the difference between the existence of infrastructure of the land advertised and access to roads that was mentioned in the ad. And the BD Agro land in zones ABC had nothing of that on the valuation date. The value of the portfolio in Dobanovci, it was assumed, was equal to the sum of the value of individual cadastral parcels. Here you can see the results of my two reports. On the left-hand side, you have a table from the first report where I covered all the cadastral parcels registered as owned by BD Agro on the valuation date. And on the right-hand side is my alternative calculation, because I was instructed by the counsel of the respondent to eliminate certain parcels according to the list submitted, where the bankruptcy trustee had established that the ownership was disputed on the valuation date, but they were nevertheless registered as owned by BD Agro, which is what I did.
In the second part of my presentation, I'll focus on the key discrepancies between my report and the reports of Mr. Hahn and Mr. Gretchek. And I'll start off from the establishment of the size of the land. Although I was informed that Dr. Hahn and Mr. Gretchek too accepted my calculation of the size in the zones A, B, and C. So the size on the valuation date is 279 hectares. Dr. Hahn started from an assumption that all the land in the zones ABC is owned by BD Agro, and he started from the size presented in the textual part of the detailed regulation plan of 396 hectares, and he deducted that figure by the size of the land sold after 2008, when the general regulation plan was adopted. The general regulation plan does not include the data on the parts of the plots or parcels that were included in the zones ABC, so that for the purpose of evaluation, the best way and the closest way to establish the size of the zone ABC is to use the graphic part of the detailed regulation plan, of the general regulation, and of GeoSerbia, as I've already described earlier. Mr. Gretchek, I must say, did not list in his report the methodology in which is established the size of the zone ABC. Another major discrepancy between my report and the reports of Dr. Hahn and Mr. Gretchek in the impact of the potential for development and its impact on the market value of the land in zone ABC. This zone is located at 30 kilometers away from Belgrade and 10 kilometers away from the airport. And it is close to E70 highway and E75 highway. However, it is not directly accessible to them from these highways, but through the intermunicipal road, the road that has not been completed to this date. The general regulation plan says that this land is intended for commercial and industrial construction. So at first sight, this may look like a good investment. And the general regulation plan, although it describes where one can build this or that type of construction, it still does not allow for construction. It does not allow anyone to start a construction in this land. Why? Because in G3 section, where it says implementation stages, there is an explicit note which says that the construction may not begin until the primary infrastructure has been built, including road infrastructure, that's Sremska Gazela, with all the planned crossroads, as well as until entire sewage system and water supply system and gas grid has been put in place, as well as the power stations and so on. So without this, one cannot count on a reasonably near period of time into the future when one can hope to start construction. I've taken all this into account in my report. I've selected comparable values. I've actually made adjustments to these comparable values. I've taken into account the perception of an average buyer or developer and all the risks that impact the development. So every developer is interested into how long one has to wait for the primary infrastructure, if there's no such infrastructure in place at the moment, and when one can start construction. However, Dr. Hahn and Mr. Gretchek did not take these into account. They feel that the key factor that has an impact on the value of the land in zones ABC is the potential for development and the location advantage. However, the vital issues to any developer that I've just described were not taken into account, and it is these issues that are the key issues based on which the developer offers a price for such land. The next discrepancy between our reports, I'd call it a deficiency in the reports of Dr. Hahn and Mr. Gretchek, is the fact that their opinion relies on information that they had not obtained or through investigation of the market itself, through that they had not done such investigation on the evaluation date. Instead, they solely rely, for example, Dr. Hahn relies entirely on the results of valuations conducted by other valuers. Without having verified such valuations and without assessing the credibility of such valuations, they simply overtake the results of other people's work. Both Dr. Hahn and Mr. Gretchek rely in preparing their valuations on the valuations by tax authorities, and that is not the same thing as the valuation of property. And the documents that the tax authorities issue are not transparent enough for any valuer to do a proper verification and to do a proper assessment of the credibility. Among the information they used, some came after the valuation date and some were quite obsolete. RESS is a technical document from 2012. So the document is RICSIP. It's on comparable evidence in property valuation. Here it says that the assessments by tax authorities are done for taxation purposes, and they're undertaken in accordance with the laws governing that area and the regulations that they are given. And they are not the same as market valuation that is done by a valuer in line with internationally recognized standards. For that reason, the result of a tax assessment conducted by a tax authority is not the same as the market value established by a qualified valuer in line with internationally recognized standards. In Serbia, there is an instruction on how to assess tax for transfer of property. We have it in the evidence. Among other things, this instruction tells us how we should value land, and the same instruction is used for valuation of land for the purposes of expropriation. For example, this instruction says that a tax authority needs to does not do the exact inspection. They do a desktop analysis. If, for example, in a land parcel there's a power line, this has an impact on, and if that has an impact on the market value, the tax authority will not know about this because they never go to visit the site. So practically the physical characteristics are not compared, although in this instruction, one can use corrective factors, such as, for example, location, vicinity of the road, infrastructure, urban settlements, the vicinity to the urban settlements, and so on. What's important is that the tax authority uses some factors to check on its previous tax assessment. It also says here that corrections or adjustments made by tax authority can go within the range of down 10% below or as much as 50, for example, 50%. On the other hand, a qualified valuer in international standards, nowhere does it say how much a valuer can go up or down. It is a matter of their professional judgment. They use their local knowledge and their own experience as a valuer. Of course, Dr. Hahn and Mr. Gretchek rely on this kind of documentation. As we'll see in a minute, we'll see what documents there are that actually were used for the comparable values. What we have on the screen is the tax authority document CE 162, and we see here at the top that the tax authority is using its previous assessments. There's no mention of the sale price. Also, the tax authority never adjusts something for size, and it is absolutely pointless that 50% square meters has the same valuation as 486. In this slide, we can see Exhibit CE 163, which shows that there's an empty slot in the line called agreed price. There's no mention of the transparency of the assessment. There's no description of the corrective factors used, or whether any the corrective factors were used. All we have is the 60,000 dinar, which is the assessment. I've just mentioned that this instruction on how real estate transfer property tax is established, the same is used for expropriation in line with the expropriation law, Article 42. So in practice, that assessment is not based on the market. It's not a market assessment, nor does it express market value. Now I'd like to focus in greater detail on this key evidence, CE 160, that Mr. Gretchek relies on as the best evidence, and Dr. Hahn forms the upward limit according to the Confinex results. According to the result from Mergude report, but also supports his findings with this document. So this is a tax assessment by tax authority requested by the Construction Land Directorate of the city of Belgrade, relating to a very important, strategically important project that is developed by the Republic of Serbia. It is intermodal terminal and logistic center in Batajnica. So this is the assessment of over 150 parcels, and I must tell you right now that in the picture on the right that comes from the report of Mr. Gretchek, that not all parcels are entered here that are located in all the in the documents that are listed here. So for the purposes of the scope of the plan of intermodal terminal, the state here has practically expropriated more. And why this is important, I'll tell you later. In the picture on the left, we can see that the distance is 15 or over 15 kilometers the distance between the zones ABC and the land assessed by the tax authority. So the distance is over 15 kilometers. In the picture in the right, Mr. Gretchek says this is close to the Belgrade roundabout, it's Highway A1, but he missed to mark a very important thing here, namely to say that the scope is bordered by a railroad, which is of vital importance to intermodal terminals. You can also see that in the immediate vicinity of Batajnica and the Shanghai settlement. So this land has no problem with the primary infrastructure, far from it. The vicinity of the railroad is for fact, and the Batajnica settlement in the vicinity of the highway. All of this is shown here. Intermodal terminals are dry, so-called dry ports that serve for the transshipment of terminal goods for warehousing and subsequent transport to distributors. And this is of vital importance for Serbia, Republic of Serbia. So it was adopted in 2015, and I must say that in 2017 and 2018, all negotiations were already underway on the selection of the bidder, on the developer, and the funding was through the IPA funds. So at that time, the plan was being the plan was adopted in 2015, and until the beginning of construction in 2020, preparatory activities had already been taken. So if we were to compare this with the land in zone ABC, which had the general regulation plan in 2008, which did not allow one to build until this day, and I've visited this site recently, I visited zones ABC, there's no mention of any development going on there. So what's needed is for detailed regulation plans to be adopted. Sremska Gazela Bridge, the plan is part of the detailed regulation plan. It was adopted in 2011. All the primary and this major infrastructure, it must rely on detailed regulation plans.
Interrupt you, but you've gone over the 30 minutes. And so, no, you can, of course, finish and conclude. I see that you're almost at the end, but you should know that you need to wrap up.
Thank you. So, by way of a conclusion, Dr. Hearn and Mr. Gretchek did not do their evaluations in line with internationally recognized standards, and they relied on data that were indirect and that could not be verified adequately, and they could not assess their credibility to an extent that is required for their opinions to be based on them. So I believe their valued amounts are not realistic and do not correspond to the market values. And this ends my presentation.
Thank you. Yes, please.
Thank you, Madam President. Good afternoon, Mrs. Ilic.
Hello.
Hello.
Mrs. Ilic, my name is Rostislav Pekaš. I'm one of the representatives or counsel to the claimants, and I'll ask you a few questions regarding your two expert reports, your presentation, and also a few documents that you referred to. I will do my best, Mrs. Ilic, to formulate my questions as clearly as I can. And most of my questions, if not all, I believe can be answered by a simple yes or no. And I would be very grateful if you could try to answer by a simple yes or no, if it is appropriate. Are we in agreement?
Yeah. Yes.
So I would like to start with your first expert report in paragraph 2.4 of your first expert report. And we will show that on a screen, and you may also consult the hard copy that you have in front of you. You note that since 1998 you have been engaged in valuation of real estate mainly for the purpose of disputes and privatization of socially and state-owned companies. Can you see that?
Da.
Yes, I can see that.
Who hired you for valuation of real estate for the purpose of privatization of socially and state-owned companies?
I was part of a team of forensic experts, court experts, and we were always recruited by the privatization agency. I think that was the name of the agency at the time because we had several changes of the name of the institution, but at the time I think that the name was privatization agency.
Would it be fair to say that you worked on assignments from the privatization agency from 1998 until 2014, 15?
No.
Did you work for the privatization agency?
I've never been an employee of the privatization agency. As I said, I've been hired within a team, as a part of a team, and teams were mostly managed by foreign consultants. Specifically, when it comes to me, let me share an example. Rothschild Consultancy was...
Well, what I asked you. I asked you to tell me the years when you were hired to work for the privatization agency. And if you intend to put a lot of emphasis on the specific words used, like work versus hire, then we might switch into English. Actually, that would save us potential translation issues.
Okay, I feel more at ease speaking in Serbian. So, in 2005, I started working at the EFG bank, and back then I was not allowed to do any external work.
Not asking you when you did not work, but I was asking you when you did work. Could you please answer my question?
I cannot remember exactly, but in the period up to 2005, I was hired as a court expert because only court experts were allowed to do valuations having such a purpose.
So you were hired on assignments from the privatization agency between 1998 to 2005, correct?
I would say it's incorrect. Unfortunately, it's not correct because the privatization started only once the government was changed in Serbia after 2000. Let's say 2001, 2002, sorry, that's when it started, the privatization process.
So then why did you refer to 1998 in your paragraph 2.4?
Madam President.
I think this is an important question for us. We need to assess also the independence of this expert, and I don't remember reading in her reports that she had been previously working for the privatization agency. So I'm not saying it is a problem, but it would be nice to have transparency. And so I understand that you're saying you were part of a team that worked on valuations for the privatization agency from 2000 to 2005. Is that right, or did I misunderstand?
We could say from 2000 until 2005. Yes, we could say it is so.
If I may, the witness started to explain the nature of her engagement with the privatization agency, which you found interesting to note, and then she was cut off by Mr. Peckers when she mentioned Rothschild Fund. So maybe
No,
she could say the nature. So she was not hired by the agency; she was hired by external consultants of the agency.
But yeah, whatever it is, please tell us now what your relationship was then with the privatization agency.
I don't have any direct links with them whatsoever. I was never hired directly by them. As I said, there would be a tender announced by the privatization agency, and for the needs of those tender, I had some engagements. Local companies were not really able to win such tenders. I worked on big projects. Those were foreign consultancy companies. Yes, please, I'm sorry.
Please.
The consultancy firm for which I was working. But it was ultimately for the needs of the privatization agency. Gospođo Ilić, da li ste... Sorry.
Did you have any similar engagements for the benefit of the privatization agency at any time after 2005?
No.
Did you have at any time after 2005 have any agency, had any engagements for any Serbian public institutions, any ministries, any agencies other than the privatization agency?
You know what, there's a lot of experience in my background, so yes, I did valuations for tax authorities. I have been hired in the capacity of a consultant to deliver lectures at the level of local governments. I do hold a lot of lectures on the topic of property valuation because I am the president of the National Valuers Association. So it's quite a lot of experience. I'm referring to more than 20 years of experience now. And now to tell you specific examples of when I was hired and where, if you want to ask me to respond to the question whether I apply to tenders announced by public companies or ministries, no. The answer is not. I have two small family companies, and we do not apply to such tenders.
Did you prepare tax assessments?
I could not remember now.
Tax assessment this year? Or any of your companies?
No.
No. I did not. I'm not the owner of these companies, however. I'm not the director either. I'm an employee, I'm in the position of a senior valuer. So I'm not sure what all of the things that the companies were engaged in, but personally I was not engaged to do such, to provide such a service.
And so if we look at paragraph 115 of your report, you state there that you have no connection with any of the parties other than as set below. Can you see that? In 115 of your first report.
Da li to može da bude?
Could you show it, please, on the screen? It would make, because the letters here in front of me are a bit small for me.
No, sorry, it's not in 115 actually. Do you have an independence declaration in your report, Madam Ilic?
Naravno, da.
Naturally, yes.
Yeah. So here you state that I have no conflict of interest of any kind with any of the parties, the legal advisors and the arbitral tribunal, correct? You do not disclose any of your work.
It's correct.
You do not disclose any of your direct or indirect assignments for the benefit of the privatization agency. You do not disclose the fact that you, or the firms that you own, have been preparing tax assessments. It's not included in this declaration, is it?
Da.
Yes, it's not included because I do not find any of that to be relevant, because this refers to me. This document bears my signature. This is my declaration, not the declaration or the signature of the director of the company. So I am making the declaration that I didn't do personally any assessment. So the company for which I'm working has nothing to do with my signature attesting to my independence in this case.
Just ask a question because I'm a little confused. I understood you to say before that you had done valuations for the tax authorities, but you did not remember in what year, and you had not done one this year. Is this you, or is this someone else in your company?
O sebi.
I was referring to myself.
Thank you.
So now I would like you to turn to paragraph 9.79 of your first expert report, please. And there you state that in subparagraph 4, actually, so a little bit further down, you state that only adoption of detailed regulation plan provides legal conditions to start development. Can you see that?
Da.
Yes, it's the one marked in yellow now on the screen, okay?
So is it your testimony that the land covered by the general regulation plan of BD Agro de Bănuți could not be developed until a detailed regulation plan is adopted for the same land?
As I said a while ago, for example, the road Sremska Gazela, which goes through ABC, most of it goes through ABC. But please don't interrupt me. I have to complete because it's really relevant to your question. So the detailed regulation plan for primary infrastructure, and this is Sremska Gazela Road, which goes throughout the ABC zone, was adopted in 2011. I have not seen in my professional practice primary infrastructure being built without a detailed regulation plan. So substations have a detailed regulation plan. Without primary infrastructure, for which detailed regulation plans have not been adopted, and this relates to zone ABC, you can simply not start development.
Understood your answer to be yes?
Yes.
Said yes, right? And then if you think the yes is not understandable without an explanation, then you give the explanation. But we simply need to have a better way of proceeding here, because otherwise we don't really understand your evidence.
Thank you, Madam Chairman. My question, though, related to the same land, to the land plots which are identified in the General Regulation Plan. These are land plots on which Sremska Gazela is not to be built. Do these same land plots require to have a document called Detailed Regulation Plan before construction can be started on these land plots? You know, a detailed regulation plan for these land plots, not a detailed regulation plan for Sremska Gazela.
Maybe not a detailed regulation plan as such, but what they need have is urban designs, urban development designs. Naturally, the law on construction is not decisive whether it needs to be an urban development design or another type of a planning document. Seeing that we're referring to lack of primary infrastructure, it could happen, but nobody knows this for sure, that at some point in the future, a detailed plan might be required. Some form of a zoning or urban development document would certainly be requested, primarily because cadastral parcels are not formed. These are still, this is still agricultural land. These are still, I'm sorry, the construction plots are not formed. These are cadastral parcels. This is agricultural land, which are partially in the zone, so they need to be split. After that, they need to be merged, which means that various parceling and new parceling designs would have to be developed, etc., etc. So on the basis of this document, the General Regulation Plan, you cannot begin development.
Okay, so do I understand correctly that with respect to the answer to my specific question, which was very precise and detailed to, related to detailed regulation plan for the same land plots, leaving aside infrastructure, the answer actually is no. This document is not needed for the land plots.
I cannot respond in that way to this question. According to my opinion, is that it would be needed. But however, I'm not an urban development expert. However, the law also does not stipulate in details the exact point in time when it's needed. These are framework things when you need the detailed or general regulation plan. So the general regulation plan for zones A, B, C is actually a private initiative by BD Agro the state was not of the opinion that the time was right for development there because there was no primary infrastructure there. So I am of opinion that this was a private initiative for, well, I don't know for which reasons, but when primary infrastructure is lacking, you cannot start development.
Mrs. Illich, you also mentioned reparceling and the need that for the reparceling to be properly documented. Would you agree with me that such a document is prepared by the investor, by the owner of the land, which wishes to change the borders of its parcels?
Certainly by the buyer. Somebody who wants to buy a certain portion will be developing a reparceling design. It could also be done by the owner. If the owner wishes to sell them as finished construction plots, it can be done by the owner. It doesn't have to be done exclusively by the buyer.
And if the new borders of the new parcels are in accordance with the general regulation plan, the cadastral authority will approve the reshaping of the parcels, correct?
I'm not an expert on urban planning. This is the work of urban planning experts. So the entire procedure regarding the approval of the reparceling designs is not something that falls under my competence.
So in your second expert report, paragraph 289, you referred to the conditions which are set out in the general regulation plan, correct? And you also displayed these conditions on the screen during your presentation today. And my question is the following. All these conditions relate to the construction of the Sremska Gazela Road, don't they?
The conditions listed in paragraph 289, only the first one of them has to do with Sremska Gazela and the accompanying crossroads. The others apply to the other infrastructure, that's main water supply, sewage collector, rainwater sewage collector, gas grid, as well as telecom installations and electrical installations. The general regulation plan gives in detail for each type of infrastructure what's necessary and requests further elaboration through a planning document.
There is not a word about further elaboration, correct?
No, not in this paragraph, but in the general regulation plan.
So could you please, focus on the second bullet point? It says that the entire infrastructure corridor will be in profile of the road Sremska Gazela. Main water supply, collector sewage, rainwater sewage collector, gas grid of the Republic of Serbia, telecom cabling. Can you see that? So this will be built at the same time when the road is built, will it not?
In this part, yes. But this primary infrastructure and the major infrastructure that has to do with the main water supply are regional infrastructure, inter-municipality infrastructure. We cannot look at this part in isolation. Yes, in this part, it will be built alongside the profile of Sremska Gazela. But here we are talking about inter-municipality infrastructure.
The regulation plan for the entire Sremska Gazela construction was adopted in 2011. You said during your presentation, do I remember well?
Da.
Yes.
And this section G3, stages in realization, actually does not relate to any conditions linked to intra-communities, infrastructure, and so on, does it?
In this section, G3, it doesn't talk about it, but I stress here again that it's explicitly stated in the textual part of the general regulation plan. In section B3, I think it's B3. These are now too many documents to know it just off the top of my head.
Document, we will pull it up on the screen. But before we, well, actually, we will look at G3 then, yeah. So you said B3, so let's go to B3.
Public roads. Yeah, it's there. It's there. Oops, sorry. Can it maybe?
Sorry, can we give the witness a paper copy of the plan?
No, we do not have that because she actually does not refer to that anywhere in her reports.
Can I give the witness a copy of the plan, please?
Yes.
You can.
Thank you.
Nažalost, previše mi je sitno, ja zaista.
Unfortunately, this is too small a print.
Then. Now, here we have the implement. No, down. It's derived from Serbian alphabet. So G3 implementation stages. Yeah, we can we agree that actually what you reprinted in your report and also presented this morning is all there is with respect to conditions to be met?
Dakle, navedeni...
It mentions the conditions where construction plots are formed out of parts of cadastral parcels. Lower tier plans have to be made, be it urban development design or reparcellation design, which is part of an urban development design.
G3, you see that?
No, G3.
Not in G3. It's mentioned in the document. G3 has to do only with the implementation stages.
So now, and you repeat that today, I think there is now not a dispute that the construction land in zones A, B, and C, you calculated the total area of that land to be 279 hectares, correct?
Done.
Yes, correct.
And then you use that entire area to calculate the price of the total of the construction land by multiplying 279 hectares by your price per square meter, correct?
I made a valuation of the construction land in Dobanovci, and before that, in my report, I had explained why didn't treat zones A, B, C separately from other construction land in Dobanovci. My valuation had to do with the entire construction land in Dobanovci.
If we go to 9.1, which is at the end of your chapter 1, surprisingly, in the first report. The total area of construction land in Dobanovci that you include in your calculation is approximately 285 hectares, correct?
Da.
Yes.
And that's the sum of 279 hectares for ABC and approximately 6 hectares for the farm and the buildings there.
Za zemljište, yes.
For the land, I valued the land.
Land occupied by the buildings. Yeah. And you made that calculation personally, did you?
I vi ste sami to računali, zar ne?
Da, da.
Yes, I did.
Asked to prepare an alternative valuation which excludes certain land that was included in the 279 hectares in your first valuation, correct?
Da.
Yes, correct.
Does that alternative valuation replace your valuation in the first report?
And those are my two valuations. The second valuation, as I said, was done upon the instructions from the counsel of the respondent. So that was not a new valuation, but an alternative calculation, because I didn't change the unit values in the valuation. I simply used the list submitted to me by the respondent.
The valuation is still valid, and in addition to it, you also offered another alternative valuation in the second report. Is that a fair summary?
Da, ono je na zahtev.
Yes, it was requested by the respondent, yes.
You independently assess the reasonableness of the instruction to exclude certain land in the alternative valuation.
Ne, to
No, it wasn't in my area of work. I received instructions from the counsel of the respondent and I acted upon those. I didn't go into the legal basis of that. Neither did I receive any information on the legal basis.
Okay, would you then agree with me generally that to be relevant for valuation, the reasons for exclusion must exist as of the valuation date?
svakako treba da prethode.
Of course, in any case, they need to precede the valuation date. I wouldn't discuss this at all because this is not my domain. I wouldn't enter a discussion regarding the legal basis for excluding these parcels. I acted upon the instructions from counsel of the respondent. I received a list of parcels for which the bankruptcy trustee had established that the ownership was disputed, and this is how I acted. This is an alternative calculation. I wouldn't say this is fresh valuation. This is an alternative calculation where some parcels were left out. As per the instructions received from counsel of the respondent.
Let us now focus on the price per square meter that you propose for the construction land in Dobanoci. So please turn to paragraph 9.89 of your first expert report. And you noted there that you identified 13 actual transactions with construction land in Dobanoci, correct?
Da, to je ono što...
Yes, correct. That is what was in the register of the Republic Geodetic Authority.
Described in your report by the land plot number, the size of the land, the price per square meter, and the date of the transactions?
No. I gave a map, a picture. This is what we get as an excerpt from the Republic Geodetic Authority. I didn't provide this information because I didn't rely on it.
You excluded 11 of these transactions without providing any detailed information other than the map in figure 34. This is right on the following page of your report. Is that correct?
Da.
Yes, that's correct.
Not explain in your report how exactly the location of these parcels makes them incomparable, did you?
Nisam.
No, I didn't do it explicitly. This information is publicly accessible on the website of the Republic Geodetic Authority. And in my presentation, I already said that I eliminated them because some of them were after the valuation date. Some had extremely low values. One of them was questionable, and I called the real estate cadastre to ask what currency that was in. And they told me that the agreement had not been entered correctly and that I shouldn't take into account this information. Some were not adequate in terms of their location, yes.
So actually there may be mistakes in the database, right?
When it seems to me that a piece of information that I get from the Republic Geodetic Authority is illogical, or that something is not okay, or that it's an outlier, or that it's incomplete, then I call them, and we have this possibility to directly communicate with the persons responsible for the database. We have this possibility as professional valuers, and then they enter the agreement and explain it to us, what it's about.
To share any of this with the tribunal or the claimants in your expert report, did you?
Ja njih nisam
I didn't select those for my comparators. In the second cadastral municipalities, you can see there were more than 300 transactions. I have to be consistent in my work. If I enter it for one cadastral municipality, then I would have to enter the 300 from the other one. That would be inconsistent. I did not rely on them in my discussion. I simply took over the information from the Republic Geodetic Authority, and I looked at 2 pieces of information in my valuation. These are shown on the map.
Yes. Would you just agree with me that on the basis of my naked eye observation, which is all I'm left with, for example, number 12, 9, they all seem to be located in an industrial zone at the outskirts of Dobanovci, correct?
Yes. They are very close to the parts of the urban land where there is infrastructure and access from the roads. Yes.
And in paragraph 990, you explained that after eliminating these 11 transactions, actual transactions, due to their location, you also eliminated the remaining 2 transactions since they are located near urbanized residential area, correct?
Yes.
So we have established that in the first step, you eliminated 11 out of 13 because they were not comparable, correct? Due to their location, correct?
No. What I said in my presentation was that I looked at different factors too. I said that 3 or 4, I think, were post-dated, were after the evaluation date, and that most of those that I had discarded had lower prices. Some had extremely lower prices, much lower than my assessment, and one wasn't clear enough, and I called the cadaster to check. So it was not based on location only.
Yeah, but in 989, the only characteristic that you mention is location. Is it not?
Yes. Yes.
In any event, the remaining 2 transactions which survived the first step were comparable, were they not?
These 2 transactions that I looked at were not comparable with BD Agro land in zone ABC and the remaining construction parcels because they have direct access from the road. For example, the one marked as A is located next to a hall, so it has full access to the infrastructure. It has access from the road. The picture shows this is asphalt road. So I thought they were not comparable. In my opinion, they were not comparable.
Okay, so we also have the transaction marked with a C. Can you see it? and the left side of the picture.
Da.
Yes.
Do you maintain, Mrs. Ilic, that this is close to residential area?
Let me see. One uses this road to get to BD Agro Farm. And there are a lot of residential facilities. Whether this was legal construction or not, I don't know. I'd rather not comment. But yes, at the very entrance to the farm, there are residential facilities. On both sides of this road, there are residential facilities.
Okay, so if we just look at in greater detail. So would you agree with me that north and west of Point C, there are fields?
Yes.
Across the street to the east, we can see some pretty substantial roofs, which definitely do not belong to residential buildings. Would you agree with that?
Yes.
And south, we have the complex of the farm, don't we?
Yes.
So now let's turn to Appendix 2.6 of your first report, and more specifically, let's go to page 25 of the appendix. So there you provide more detailed information of on the two transactions that we have just looked at, correct?
Da.
Yes, that is correct.
So the land that you said was close to an asphalt road in the eastern part of the picture that we had is the one which here is marked as number 1, correct?
Yes.
And it sold in August 2015 for 33, almost 34 euros per square meter, correct?
Yes, correct.
The other one in the eastern part of the in the western part, left side of the map, which is close to the farm, sold in July 2015 for 28.40 euros, correct?
That is correct.
So now in paragraph 980 of your report, the first one, you state that it is appropriate to use the same comparables to the valuation of the land in zones A, B, and C, and to the land of the farm, correct?
Da.
Yes, correct.
Let's now go to paragraph 991 and 992 of your report. Do I understand correctly from these paragraphs that instead of relying on the 2 or 13 actual transactions, you relied on 5 asking prices for construction land in Dobanoci?
I don't know what you mean by saying instead. I explained why I rejected those.
English right now is that you relied on 5 asking prices for construction land in Dobanoci, correct?
That's correct. 5 advertised prices.
So we can't see that from table 22, actually, that there were only 5 asking prices. But we can say it from, from Appendix 2.6, page 28. And Mrs. Illich, do you provide a map showing where the respective land is located?
No, I did not include a map. However, in the advertisements, there's always a map. So when an ad comes out, so the real estate agent profession is well regulated in our country, and they have to strictly observe the way in which advertisements are placed. As a result, maps are always parts of the ads, but this is data from my private database. These are historic data where I preserved the picture of the advertisement as well as the text from the same ad. But definitely they are located in Dobanovci Cadastral Municipality, with one exception, with its location in Batajnica.
Well, Mrs. Illich, we have just seen that you were very picky when it came to actual transactions, and you showed great sensitivity to the exact location within Dobanovci when it came to these actual transactions. Isn't it inconsistent then to accept asking prices, only 5 of them actually, and one of them not even in Surčin, without looking at the specific location of the land covered by these asking prices?
The question was whether it was inconsistent. Can you please...
Was it consistent for you not to look at the specific locations of the land covered by the asking prices, even though you had been very sensitive to the specific location of the land subject to the actual transactions that you identified?
Thank you. No. I felt that for the correction of the 2 samples to be more than 50%, had I taken these into account. As you could see in the picture, one is located next to the asphalt road with all the infrastructure provided. It is land that can't be compared with BD Agro land. If I were to do corrections or adjustments over 50%, which is what Mr. Gretchek said in his report, if we do over 50% of adjustments, then it is not a comparable value. So I did not take the 2 transactions into account, because in that case I would have had to do over 50% of adjustments.
So if I understand correctly, the answer to my question is no, I was not consistent, right?
The interpreter apologizes. Did the council say no, I was not consistent, or I was not inconsistent? Sorry. So the lady is speaking. The 2, okay, sorry, the interpreter apologizes. I tried to make sure I heard you correctly. Sorry, if we can go back, please.
Ask my question again. You excluded actual transactions on the basis of specific locations. You did not look at the specific locations for asking prices, and you maintain that this is a consistent approach. Do I understand that correctly?
I must say that you are putting the words in my mouth that I did not say. These 2 examples, these two transaction samples included in my app, because of the access to road and because of the infrastructure, had been rejected because I would have had to adjust them by over 50%. Because of the access to road, to the asphalt road that you could see, one of them is lying directly next to the land and next to the hall, the big construction. So it had been rejected because my adjustment would have had to be over 50%. It is marked as A in this picture.
Molim vas, da li vidite asfaltni put?
So can you see the asphalt road from Al-Sharatito Road? It's the main one going right through Dobanovci. So C, item 2, has direct access from the asphalt road and the infrastructure.
Yeah, so C has access from the asphalt road, which also connects the farmland. Oh, I mean the land of the farm, I should say, right? The farm is actually on the same road, Ulica Ivelole Ribara, isn't it?
I would like to clarify something here. The land, or other construction land, as it's called, I can't remember off the top of my head, but it's around 15 hectares. We are talking about ABC zone, which has 279 hectares. The land of the farm, as I explained in my report, is around 15 hectares. Yes, that part has infrastructure, has everything. But if you compare it with the entire land of 279 hectares in zone ABC, which does not have access to the access road, or in some points I just could not physically access the land because it was just a meadow, a cornfield.
Mrs. Ilic, what do you think is better from the developmental potential for the purposes of building, for example, large warehouses, logistical centers, industrial complexes, etc.? An access from a small municipal road, or future access from Sremska Gazela?
Yes, one day when it's developed, it would be an intermunicipal road, then naturally that would make a better access because the road would be a major road. That's why it's, of course, important that you have a direct access to a highway.
Are you aware, Mrs. Ilic, of the fact that in 2014, the city of Belgrade allocated first money for the construction or the preparatory works for the construction of Sremska Gazela, and first expropriations already started?
The funds invested, you are talking about, I don't know. I could see in the documentation somewhere it says that the city of Belgrade budgeted this, but this does not mean that this budget allocation went to this investment. Serbia has in its territory works going on in different locations ever since the government changed in 2012. So there's been intense development activity. So I don't know whether what was planned in the budget had eventually effectuated. But based on the evidence you show here, I can see that expropriation in Probari was going on for the purpose of Sremska Gazela Road.
And are you aware, Mrs. Ilic, actually, that this asphalt road, which is here named as Ulica Ivelole Ribara, then extends to zones B and C?
Yes. It does not extend to the entire zones. It goes partly through the farmland, but not until the end of the plot.
Of zones ABC, please, and not only this little excerpt. Thank you.
I do not know if you have such a degree of detail, but we will. We do not have a comparable level of detail, but I think the witness responded. And I don't think that you are raising an objection, are you? let's now look at C 516.
Mr. Pekar, before you go there, as long as you're on the same topic, that's fine. Once you get to a different topic, maybe it would be a good time to take a break, because I just see we've been going on hour 40, which is fine. We can still continue a little.
Yeah.
It's just so you know.
If you can, like 10 minutes.
That's
would
fine.
It be fine?
Yeah.
Okay. Yeah. Thank you, Madam President. Let's look at document CE 516. This is the International Valuation Standards from 2013. And please, I would like you to turn to paragraph 57, page 24, which addresses, among others, also the use of asking prices, correct? Let's wait for it to be.
Da.
Yes.
Screen for everybody. Yes. So it states that the asking prices can only be used if the relevance of this information is clearly established and critically analyzed, correct?
Yes, correct.
Mrs. Ilic, do you believe that you provided a critical analysis of the asking prices, given that you did not indicate where the land is located?
It is certainly relevant. It's located in Dobanovci, in the cadastral municipality that was covered by me. So Dobanovci includes very relevant land. If we're going to discuss the relevance, then I would say yes, it is.
Now I will show you Serbia's submission on quantum. It's paragraph 68. At the end of that paragraph, Serbia says, it seems that the only plausible explanation for Dr. Hearn's approach and reliance on indirect information is that an analysis based on actual land sales would yield far lower prices, as demonstrated in Mrs. Ilic's valuation. Can you see that?
Da vidim.
Yeah. Mrs. Ilic, actions to assess the value of construction land in Dobanovci?
I did not, but I've taken them into consideration. Step 1, IVS. Please, if you can go, IVS, paragraph 56 and 57.
Izbor
Mrs. Ilic, this is cross-examination. This is not a lecture. If Mr. Professor Jeric
Could you please let the witness at least finish?
This is not an answer to my question. You will have the redirect, Professor Jeric. Therefore, let's look now at what Dr. Hearn said. First report, paragraph 89. So he, in 89B, Dr. Hearn sets the upper bound of his valuation at 30 euros per square meter, correct?
Da.
Yes, correct.
And the two actual sale transactions that you included for Dobanovci in 2015 were one at 28.4 and the other one at 34. Do you recall that?
Izvinite, nisam ispratila pitanje uopšte.
I'm sorry. I'm trying to understand how are you connecting Mr. Hans upper bound? Could you rephrase this question or repeat it, please?
You may also wish to, because since you have the benefit of having... No. Yes. You also have the hard copy of your report, and you may wish to consult Annex 2.6, page 25.
Could you put it on the screen, please?
I can put it on the screen, but then we will have to remember 30. It's either or, Professor Cohen. But maybe 30 is easier to remember.
Okay.
Yeah, perfect. So the prices we see there is almost 34 and 28.4 for the actual transactions in Dobanovci, correct?
Yes.
Correct. It is correct.
Su registru.
These are the registered prices.
So Dr. Hearn's upper bound is lower than the registered price for transaction 1 or A, and only slightly higher than the registered price for transaction 2B, correct?
Yes, it is correct, but how does this relate to my evaluation? Where does that question lead? Because these are two sales transactions that I rejected because of direct access to asphalt and infrastructure. I do not see the purpose of you comparing the data I've discarded with Mr. Hans' valuation. Can you explain?
It is for the tribunal to decide on this, and I will give the tribunal the benefit of the break.
The tribunal will assess this. We have your answer.
Apologies, Madam President, I spoke over you. I think it's a good time to break.
Good. That's fine. Let me just try and see where we stand and how we will go forward. Do you have an approximate indication of the time you still need?
I am more than halfway through,
Yes.
and I will have a much better understanding after the break. I will.
So that would be, assume it's maybe will end around 4:30.
Definitely before 4:30. I would expect
Yes.
rather around 4.
But then there may be redirect, there may be questions by the tribunal. No, we're just trying to think ahead about the damages experts. How much time will you need tomorrow for the damages experts? Do you have an indication on your part of the cross-examination time?
That will depend on the length of answers.
Yes.
But
I can appreciate that.
Yeah, a speedy one would be 1 hour 15 minutes, I think.
Yes. And how is it on your side?
We're not sure. Probably 2 hours. But
About 2 hours, yeah.
But we have still enough time, unlike the other side, I would
No,
say.
no, that I know. I'm just trying to figure out. Plus, of course, there's the presentations, right? No, the reason for asking is that we have time. We can finish without problem in the course of the day tomorrow. If we can, the tribunal would like to have some time in the course of the afternoon for internal discussions when
informal and preliminary, of course, because this is before we have your post-hearing briefs, but still it's at the time when we will have heard all the evidence. And that is why I'm trying to assess around what time we will end tomorrow. But is something like 3 o'clock reasonable?
Well, Madam President, I think that we can calculate that having in mind the time that is left for claimants and the time that is left for the respondent after today. It would be easy to calculate.
Was easy, yes, but we are not at the end of the day yet, so that's why I'm trying to make some advance work. Maybe, no, the reason for asking this is, do we want to start with Dr. Hearn today, depending on when we end now? Is this a possibility or not?
Well, we don't have anything against Dr. Hearn providing his presentation today, but we are not
You're
in the
not ready
situation
to do the cross.
No.
I mean, that's
and I believe that we discussed that on Friday, Madam President, and it was, at least I understood, that you would prefer to always have the pairs of witness on the same day.
Yes, that's right. That's right. Absolutely. So maybe we take the break now, then we see where we get today and take it from there.
Madam President, you didn't warn the witness.
I did not admonish the witness. Yes, and do you understand when I speak English? Yes, I should please ask you not to speak to anyone during the break.
Yes, that's fine. Okay,
Good.
Thank you.
Thank you.
Thank you.
Ms. Ilic, are you ready to continue? Before I give
Yes,
you the
thank
floor back, Mr. Pekash, I should just mention that the PCA Council, who helps us and watches the video, thinks that she saw yourself standing up and walking out of the room with your phone next to the ear. So I just like to make sure you haven't spoken to anyone during the break about your testimony or the evidence or the case.
Thank you. I didn't use my mobile phone.
Fine, so that must
Yes,
have been
thank you.
something else. So
Thank
I'm
you.
clear I raised it, so this doubt is cleared. Excellent. Mr. Pekash, please.
Thank you, Madam President. Mrs. Ilic, I would kindly refer you to your slide. It's not numbered, but it states valuation of BD Agro construction land in Dobanovci. I know it's perhaps something like the 10th slide. Yeah, that's the one I have. Yeah. Are you with me? Yeah. And here you refer to a 30% downward adjustment that you applied to the valuation of BD Agro's construction land in Domanovci. And here on this slide, you say that this is for the difference between characteristics of BD Agro representative sample and representative comparable, availability of the infrastructure and access to the roads. See also RE 540, correct?
Right.
When reading your report, I had the impression that you originally applied this 30% discount on the basis of the median size of the individual land plots comprising the land BD Agro owns in zones A, B, and C. Do I recall correctly?
For the valuation of Dobanovci construction land, I didn't apply adjustment for the size.
You can.
This is not adjustment for the size, if I understand your question correctly. For other cadastre municipalities, for other land, yes, but here in Dobanovci, it was not adjustment for the size.
You're, of course, free to speak English.
I'm sorry.
We just...
what?
Yeah, I noticed.
We just thought that Ms. Ilic would be more comfortable, and she said she's more comfortable with Serbian, but...
Yeah, that's what I understood. So, and I think you didn't do it on purpose. You just switched.
No,
what do you prefer to continue?
Na srpskom.
Okay.
In Serbian. Thank you.
Please refer to paragraph 9.1 of your first report. And there you state, I will read it out loud. When comparing construction land sale transactions with construction land in Dobanovci owned by BD Agro, I use representative median transacted size and median price in euros per square meter. Given that median size of BD Agro construction land cadastral parcels in Dobanovci is 17,372 square meters, and median transacted size of construction land is 30,000 square meters, with a median price of 21 euros per square meter. I apply downward adjustment of 30% as a reflection of my experience in valuation of land. So do I now understand correctly that the first, I don't know how many sentences, so the last sentence actually is not connected with the previous sentences in 9.1?
Tako je, tako je.
It is correct. The last sentence it says I applied an adjustment of 30% as a reflection of my experience in valuation of land. This relates to the existence of infrastructure and access road.
So you apply no discount or bonus or premium, I should have said, based on the size of land, do you?
No, I was of opinion here, since this is construction land, that this is a median, approximate median size.
Could I please refer you to that will be the penultimate of your slides, the one which discusses CE 160 tax assessment Batanica land. Yeah. Please focus on the land plots which are shown there as expropriated at 37 euros per square meter, right in the middle of the picture. Can you see any roads or infrastructure there?
No.
So the ones which are marked as a group of parcels are there, though I have to say these are not all of the parcels which were the subject of this valuation. Many more were covered, 150 or more than that. So I do not know what was the logics of Mr. Gretchek when he grouped only a part of parcels which were evaluated in this way. So a document of an tax authority cannot be properly checked, because if we were to see all of the parcels evaluated by the tax administration, we would see that there's no reason whatsoever why would a parcel which is close to this area would have another assessed value. So I cannot establish what is the exact way in which the tax administration carried out this valuation. I do not see such data. This is an example of an untransparent procedure by the tax authority, and which is used for market valuation purposes. It probably suffices for expropriation because it is in line with the law. However, for the needs of market valuation, I cannot discuss on this piece of data in terms of its in terms of how accurate it is. Why did they made an assessment of 32? If we could have an image of all of the parcels assessed by the tax authority, you would see that there's no line of logics there. So I would never use this piece of data because I cannot check if it's accurate or not.
It was completely different. My question was, can you see any roads or infrastructure leading to the plots of land marked as expropriated at 37 euros per square meter? Can you see any roads or infrastructure leading to these land plots?
David?
Yes, naturally I do, but Mr. Gretchek did not mark them. So the ones which have been assessed by the tax authority as 28 euro, these parcels are public land, uncategorized roads. All of these are dirt roads, yes. But Mr. Gretchek did not mark it as such. On this occasion, the railway land was assessed, but it's not marked in the assessment, so there's a railway line above. Unfortunately, such an incomplete image is not adequate for me to provide much commentary or to confirm that it is correct or not, because I lack sufficient information to do that.
Mrs. Ilic, do you agree with me that the 37 euros per square meter price is how much Serbia is willing to pay for such land as we see on this picture?
Yes, because it's a document developed by the tax authority, done for expropriation purposes in line with the law.
Now I would kindly ask you to go to paragraph 4.52 of your first report. And there you criticize Mr. Hearn for comparing BD Agro land with land fully equipped with infrastructure and access to the public road with respect to document CE 163. Can you see that?
Da.
Yes, I can.
And then right above the picture, you state that the value of such land was assessed by the tax authorities as 51 euros per square meter. Can you see that?
Da.
Yes, I can.
Technology to split the screen. I don't know if that's possible. I would also show you paragraph 88 of Mr. Hearn's first expert report. 88, yes, in his first report. Perfect. Now let's leave it this way. This is easier. So there in table 3.4, you can see that the comparable transactions that Dr. Hearn uses state prices between 20 and 37 euros per meter square. Can you see that?
I can see the document, yes.
With me that he did not use the transaction at 51 euros per meter square as his comparable?
Yes, he dismissed that one, the comparison to Stara Pazova and Nova Pazova.
Thank you. I then have a question about, because you stated that you are the owner of two companies which do valuations in Serbia. Do I recall correctly?
No.
No, I am an employee in two companies.
How many employees do these companies have?
Now, due to COVID, I don't know. So for DOO, I think they have 5 employees, but because of the situation with COVID, I really don't know if there have been any changes. Millennial has 2 employees.
Is your husband and daughter among the employees of these companies.
Tako je zapravo.
Yes, correct. They are the directors of each of the companies. I said that these were family companies, yes.
Thank you, Madam President. No further questions.
Thank you. Dr. Cherish.
Thank you, Madam President. I will have a couple of questions.
Yes.
Now, the question was asked at the beginning about Mrs. Illich's involvement in tax assessments conducted by the Serbian tax authority. Could she say that whether that was a tax assessment by the company or by herself, personally?
I think she answered my question by saying it was by herself.
Okay, sorry.
But if I misunderstood, you will, of course, say so.
It was for the purposes of the tax administration. I have to correct myself. The latest valuation I did for the purposes of the tax administration, I was hired by a client who wasn't happy with the assessed value assessed by the tax administration. Those were annual taxes on real estate. And the client hired me, and I did checks of the document that he submitted to me, and I had to contact the tax administration and ask them based on which sale transactions they had done their assessment. So practically it was for the tax administration, but not...
A slight misunderstanding. Now, I will rephrase the question so you can answer it even more precisely than you said now. Now it's more clear, but let's try to be even clearer. Have you been hired by the tax authority of Serbia?
Ne.
No, I haven't.
So I can assume that you have not received any payments from the tax authority of Serbia. If you
Madam President, I believe that we should keep to the rule that leading questions are not supposed to be asked on redirect.
No, let me ask this.
Please.
So we have clarity on this. I thought before listening to you that you have acted for the tax authorities in respect of tax assessment valuations. Now you mentioned that the latest involvement in a tax assessment was not for the tax authorities, but for a client of yours who had an issue with the tax authorities. Did you, on other occasions, act for the tax authorities?
Ne, uvek sam...
No, I did not. I was always hired by clients, but for tax purposes, whether it was a tax or an assessment done by the tax administration. For instance, conversion of the right to use to the right of property, when this activity started with conversions of construction land to the right of property. Quite a lot of clients hired me for this purpose.
In the actual topic, we're interested in who was the client. Did you ever have the tax authorities as your client? I think that is what we would like to know.
Ne.
No, never. I was never paid by the tax administration.
I have just one more question, and that relates to the point where Madam Ilic was cut off by my colleague, Mr. Pecker, so I will use the opportunity to get her a chance to finish what she wanted to say. And the question was, if I if I'm paraphrasing it correctly, that, whether she used real transactions and why she didn't use real transaction is in her valuation. And then she started by saying, well, step 1, and she referred to IVS 56 and 57. And if she could finish and explain that part, what she used and what was the sequence of steps. Thank you.
Hvala.
Thank you. If I may just get on screen IVS 2013.
And that is at page 24.
Da, tako je. Dakle,
Yes, correct. In the entire valuation of the BD agro lands in different cadastral municipalities, I first used the sale prices, the prices of transaction from the database of the Republic Geodetic Authority. That's an organized database on realized transactions. My first source are always sale prices from agreements. And this is in line with IVS standards. And here, in paragraph 57, it says that you first look at prices achieved in sale transactions. And if you don't have those, or if those are perhaps not adequate, then you use asking prices. Of course, with a critical analysis of the asking prices, and further, this paragraph talks of valuers using adjustments in order to first reflect the difference in the transaction itself, whether it's a market-based transaction or not, and what the circumstances were, or whether it was perhaps an asking price and not a realized transaction. And further on, it says there are adjustments for physical characteristics, economic, etc. That's what I wanted to say.
Any further questions?
No further questions. Thank you very much.
Do my colleagues have questions? Yes?
Good afternoon, Madam Ilic.
Dobar dan.
Good afternoon.
Is it possible to put on the screen figure 35? Any of the parties? 35 on the report, first report. Is the image with the two properties that were not included in the analysis. No, not this one, the next one. 35. Yeah, here. So here we see A and C. My question is the following. What would have been the impact of including C in your evaluation? Is it clear?
Da, jasno je.
Yes, it is clear. Here you have access directly from the asphalt road. Here we have infrastructure, and the correction here would be around 50%.
It would be 50% more than my point is you made a final evaluation, okay, an amount, And my question is, what would have been the impact in the amount of your evaluation if you would have included this property shown as C? That's the point.
Any correction of 50% would be an inadequate comparator. I simply believed that these were not adequate comparators for the BD agro land. I'm here not talking about the farm, but I'm talking about those covered by the general regulation plan. They had dirt roads.
Just about the impact. I wanted to know just what would have been the impact if you would have included. Thank you.
I cannot tell you this now. I would have definitely made a bigger adjustment than the one done for the asking prices, because the advertised information on land that was offered on sale included agricultural land in the construction zone that had access to roads, etc. And for all of the advertised land, there was proximity to roads or access from roads. And here we can see direct access from an asphalt road. And the parcel A is next to a hall, and probably the owner asked for it to get an expansion because there was infrastructure there, electricity, water, sewage. So they're not comparable.
Madam President.
Thank you. Can we please show on the screen Mr. Gretchek's presentation on page 4? Thank you. So this is the table of the different divergences in your valuations. You agree with the divergences? I mean, you agree that these are, they are correctly restated here?
Da, velika.
Yes, I do. There are large divergences, not only in the result of the valuation, but generally in the discussion of the evidence and the checks of the data that the opinion relies on. There are huge divergences.
Yes, but are there important divergency topics that are not listed on this table?
In my presentation, I presented our key disagreements. If we eliminate the calculation of the size of land in zones A, B, C, because Dr. Hen accepted my calculation.
You criticized him in your presentation, but to me, he had agreed to your size calculation. So that is not a problem anymore. Do we agree?
Tako je, Toni.
Yes, that's no longer a problem. Yeah, we can disregard that.
Is not on his chart that you consider an important divergence?
Faktički,
on the left-hand side, Mr. Gretchek put his estimated value, and on the right-hand side, he gives my valuation as if it were not valuation. 21 is only one step in my valuation. After comparing my representative sample for ABCOBD Agro and the representative sample of the advertised sale of land, my valuation is 14.7, and I don't know why it's not on an equal footing with his estimate, because it's not 21, it's 14.7.
Is written here. It says 21 less 30%. So do you, we have it here.
Yes, I can see it, but it's given in brackets as if it were not my estimate. I don't know why his estimate is given as a figure that he got.
Disregard the bracket, right? On the conversion fee, Mr. Gretchek said that you have, I understand that you are both of the view that the conversion fee is based on 50% of the agricultural land price. And then he noted, and that I would like you to comment on this, that when here you have calculated this by 3.4 euro per square meter, while in your own valuation of agricultural land, it was 1 euro per square meter. First of all, is it correct that you have two different values for this price? And if so, why?
Yeah.
This is not an assessment. This is a simulation of the determination of the fee in a way in which a tax authority would normally do it. In my report, in the annex, under conversion fee subtitle, I explain the procedure step by step. So the authority that has to do the assessment of this conversion fee is the tax authority. How do they do it? They take from the previous year the assessment they made for tax purposes, the annual taxation calculations. And of course, if I'm to simulate this procedure and arrive at what the realistic figure would be, I would then go and check what tax was assessed. There's a table I would need to look at that shows the prices in individual zones that were determined by the tax authority for the previous year. So for 2014, the 3.4 euro is the price of agricultural land in the zone in which BD Agro land was located. So the correct simulation of this fee, this is not something we are assessing, the tax authority does so in real life. So I mentioned that in my annex, and what is done is that you take the price for the zone for the previous year and you use 50% of this price for agricultural land. So the price in the zone for agricultural land is 3.4. And this is the best I could do to simulate the procedure that would normally be taken by the tax authority, which has the authority to determine the conversion fee. For the conversion from agricultural law to, from agricultural land to construction land. So it is not my assessed market value.
But my question was going a little beyond that.
when it then comes not to the calculation of the conversion fee, but to the calculation of the agricultural land price, would you not, being in the same area, have to take the same price for the same time?
The city of Belgrade issues once a year a decision on the prices in respective zones, and these are the prices that we are using for these purposes for determining the conversion fee. I explained that in my first report in an annex.
Can we go to the, maybe I misunderstand something, but I'd like to clarify this. Can we go to the valuation of the agricultural land, not the construction land that you make? Where do I find this in your report? It should be, so you have the review of Mr. Gretchek's valuation of the agricultural land. Where did I just saw it? That's page 44, and is yours right there too? Let me see. You probably know your report better than I do, actually. Can you help me and tell me where you have valued the agricultural land?
Dobanovci.
For Dobanovci, is that what you're asking about?
Yes.
Here it is. Page 115. It's, oh, sorry, this is valuation of construction land.
Page 111.
Izvinite.
And page
Evo je.
111.
Da, jeste, stoji da.
That is correct, 111. Sorry, 112.
So what is the, and here the price per square meter is €1, right?
Tako je.
Yes, correct.
€1 here and 3.4 when we calculate the conversion fee.
I need to explain this. Here we are talking about determination of a fee, which in real life is done by a tax authority, by the local self-government body. So, and I explain in my addition to the annex an explanation, description of how this is done. They take the price of agricultural loan in this particular zone, and then they calculate, they use 50% of that price. They
doesn't change, or is the price different for the conversion fee than for something else? If I go and I buy the land, the price is so much. If I calculate the conversion fee based on the price of the land, why is it different?
The law says that should be so. We have description in the law how conversion fees are determined. We have the law on planning and building and the law on agricultural land. And in my report, I refer to these two laws. That amount is not something I'm determining. If I want to do a conversion today of my agricultural land into construction land, I will not hire a valuer to do this. I will go instead to the local authority, where the tax authority will determine the fee based on the price in the zone where the land is located for the previous year.
And so the price that the tax authority would establish would have no relationship with the market value of that land?
That's the price in the zone that they say is market price. That's what I was trying to explain. This is what the tax authority is doing, and they do so for different taxation purposes, for expropriation as well, which is not the same as the market assessment. It is done on the basis of a number of laws. And that is why in my report, in the appendix, I describe the procedure in which this fee is determined. So that's all in line with the relevant legislation. And again, it is done by a local self-government body, namely the tax authority from the respective local self-government unit.
If the tax authorities, that's not specifically related to that, but to your general criticism of taking into account tax authority assessments, are there assessments generally higher or lower than what you would say is the fair market value?
A tax authority does this for the purpose of filling the budget, and that is true of all the countries, not just Serbia. So, when speaking about the real estate tax, yes, these are higher values. When it comes to the transfer of absolute rights, as you could see for yourself, the deduction is 10%, and then there's no limit for the increase for the higher band. So if I come with a contract to show that I've bought some land at 100,000 euro, they can say, oh no, you did not buy it for 100,000, you bought it for 150, regardless of me having this contract showing the price, the contract price. So every tax authority regulates these things the way they think fit. That's my personal opinion, of course. And
it sets expropriation prices. Would it put it above market value?
Let me tell you, it all depends. In accordance with the instruction I mentioned on the determination of tax for the transfer of absolute rights, the same document is used for expropriation purposes, and then the tax authority does not visit the site. They do the assessment based on previous assessment, not on the basis on the sales agreement or contract, but on basis on previous assessments. If in their local government unit they have not had any transactions, then according to this instruction they have the right to look elsewhere, to find some established assessments conducted by other tax authorities or normally the bordering municipalities. This needn't be relevant at all for the assessment of the value of land within the boundaries of their municipality. So this is very often a value that does not correspond to the market value. And I'm now talking about the market value as defined in international regulations, but there's legal basis for what they do.
Can we look at page 15 of your presentation? It's entitled The Concept of Market Evidence and Relevant Valuation Standards. Yes, there you I have calculated that it's 15, but I may be wrong because I'm working from the printed version that has no numbers. Yeah. Yes, this is it, yeah.
There you mentioned that Dr. Hearns relies on third-party valuations, and that is not acceptable. It seems to me that you rely on the Confinex report. That's a third-party valuation as well, isn't it?
Yes, I rely on it, but just for the purpose of defining the cadaster parcels on the valuation date. I had no other way of getting this. The data in cadaster are now relevant for the present time. And to be able to have data on the quantity and size of the parcels that are subject to the valuation, I used the December Conifinex report. It's December 2015 report, because the report said that they had made a table based on the title deeds from the cadaster, and they indicate the numbers of these title deeds. And on top of that, they mentioned that they had the inventory list, which is the list of fixed assets, where we have a list of cadaster plots, or actually the plots that were owned by BD Agro before the valuation date, or immediately before the valuation date. So that's the only purpose for which I use this report, because I had no other way of obtaining this data.
Thank you. I have no further questions. So if there are no requests for clarification, that ends your examination, Mrs. Ilic. Thanks for your assistance.
Hvala.
Thank you.
So now it is 4:25. Do you wish to end here? Do you, yes?
Yes, well, Dr. Hearn is not ready with his opening presentation.
Sorry?
Dr. Hearn is not ready with his opening presentation.
Yes, I can understand that.
So
yeah, fine. Then we will hear the two damages experts tomorrow, as we had said on Saturday. Is there anything we should think of in preparation for tomorrow?
Nothing on our part.
You're aware of the
Nothing.
time that is left?
Yes.
I mean, you will be aware soon of the time that is left on both sides. Yes? Good. Have a good evening then.
You too,
Goodbye,
thank you.
everyone.